Good morning, Ms. Rivers. Are you able to hear us?
Good morning. Yes, I am.
Great. All right. Then let's get on the record in the State versus Leslie Singleton. The case number is 00SC09016, and we are here for what will likely be part one of the motion for new trial hearing in Mr. Singleton's case. Before we go any further with anything I have to say, Mr. Hort, good morning. I'd like you to get on the record, although I think it's been filed, your verbal waiver of your client's presence, because we took all the steps we could to connect him with these proceedings. Ware State Prison is here. Did something change?
Yes, Your Honor, and I think thanks to the court and thanks also to Ms. Piper, they were able to make arrangements for him to appear virtually.
Oh, well, never mind. Okay, excellent. Let me see what that looks like. Are you Mr. Singleton? Yes.
Good morning, sir.
Good morning, and thank you, Ware State, for making Mr. Singleton available. We had been told that the video space had been booked at the facility where Mr. Singleton was housed. So we made the necessary steps to have Mr. Singleton brought here to court in person. Mr. Hort provided an explanation as to why Mr. Singleton preferred to appear virtually, which meant he wasn't going to be able to appear at all. And Mr. Hort, you had filed something waiving Mr. Singleton's presence. That's now moot because here's Mr. Singleton. Mr. Singleton, are you comfortable having us move forward with you appearing virtually rather than in person?
Am I comfortable being virtual instead of in person? Was the question?
Yeah, you're in Ware State Prison right now. You are not sitting in courtroom 8D in Atlanta. You have a right, sort of, to be here for this hearing. And your lawyer is here, but you are at Ware State. And so it's not easy for you and your lawyer to have a private conversation right now. But you can waive your right to be by your lawyer's side. Are you willing to do that?
I'm okay with that.
You're okay with that. Excellent. All right. Now I'm going to have the good folks at Ware State mute you again. And then if it becomes necessary for us to hear from you, we'll do that. Otherwise, you are free to listen as we go forward. All right.
Your Honor, at one point he was pointing to his ear. Can you check to see if he can hear sufficiently?
Yeah. Mr. Singleton, were you able to hear what I was saying? I just used unclear words, or was it something different?
I can hear. You are the worst in regards to audio. I can kind of hear them pretty good, but while you're speaking, it's kind of muffled. But I was, context still what you were saying.
Okay, thank you. If someone says something and you can't hear it, wave your arms, do something, and we'll keep an eye on you. And if we see the arm waving, then we'll ask the folks helping you out there to check on the audio system. Okay. Great. All right. Mr. Hort, you had shared with Mr. Armstrong and me a particular order in which you wanted to go through things. We are together until noon. That's how much time we have this morning. Having worked with you before, we won't get through everything by noon. So I'm looking to you to prioritize in a way consistent with this one request. I know we've got Ms. Piper from the Attorney General's office. There may be someone from the State Bar. If we have people who are here because of your efforts, successful or frustrated to get records, let's handle that first so they can be on their way. And whatever remaining time we have today, we can then focus on the arguments that you set forth in your various amended motions. Does that work? And that may be what you asked to do anyway, but if you didn't, that's what we're going to do.
Great minds think alike.
All right. And tell me who is at the table with you.
This is my investigator, Tony Lee.
Last name again?
Alec, A-L-I-G, Your Honor.
Great, thank you.
And as a Michigan kid, I will mispronounce everybody's name here.
Okay,
Judge, I would like to first start out with Ms. Piper. That's the easiest one, so she can get back to work.
all right, let's get Ms. Piper on the screen. There she is. And so we can get Mr. Armstrong, do you mind either moving the screen, it rotates, or sliding over so that Ms. Piper can see? However you want to do that. And then Mr. Hort, I'm fine with people remaining seated. You're also welcome to go to the podium. I don't really get wrapped up about that. So, but I just need you all to be in front of a camera so Ms. Piper can see you.
Did you want just me on the camera? Because it's just me and Miss Piper.
No, I'm going to add Mr. Hort, but I was going to find out where he was going to be for his presentation.
I didn't know if you want me to push it so we were both in the screen.
I don't, just you. Okay, you're going to stay there? Excellent. All right. Those are the important folks. One last thing I haven't opened it yet, but someone delivered records from pardons and parole. And I will review those maybe based on the conversation that we have today. So the one submission that has been provided, still sealed in some impressive tape, is from pardons and parole. All right. So, Mr. Hort, why don't you, anything else procedurally before we dive into things with Ms. Piper?
I don't believe there's anything we need to do at this point. There are additional procedural matters, but I think to get these folks on the way would be the best and easiest thing.
Mr. Armstrong, anything procedurally before we work through Ms. Piper's input?
Not that I'm aware of.
Okay, great. Then let's get started.
Thank you. Your Honor, I had filed a subpoena asking for GDC records and also as to whether Sergeant Taylor and CERT, C-E-R-T, member Bess, B-E-S-S, whether either person had authorized a document that Mr. Singleton was not a member of a gang or refuting any alleged gang affiliation.
Yeah, give me some context for that because you dropped these names. I know what GDC is. Who's Sergeant Taylor, as best you understand?
That's a good question because in my communications back and forth with GDC, they communicated with these persons and those persons did not wish to talk to me.
Who do you believe Sergeant Taylor to be?
I believe both persons would have been involved one way or another with Mr. Singleton, either as counselors or working his floor, somehow where they would have had knowledge as to who he was, what he was doing.
GDC employees.
Yes.
Got it. Okay. And so you subpoenaed GDC to get records of what?
From both Sergeant Taylor and CERT member Bess as to whether either person had authored a document that Mr. Singleton was not a member of a gang or refuting any alleged gang affiliation.
And the significance of either of them. Ms. Brady, you need to stay mute. Or I'm going to have to remove you from the call. I don't know who Ms. Brady is, but stay muted, please. The significance of, let's say it was Sergeant Taylor who wrote a document that says Mr. Singleton's not in a gang. How does that relate to a new trial?
Well, my initial request is in conjunction with the parole board records, whether there is any records that you are going to be reviewing that said he was a gang member. Did they then receive the letters from these two people saying that he was not? I think I will tie it into the 8th Amendment.
Okay. And do you have this document or you just believe a document is floating around out there of unknown authorship that says Mr. Singleton is not a gang member?
This is based on what I've been getting from Mr. Singleton.
Okay.
Long story short, Ms. Piper has advised that neither one of those two people authored a document that he was not a member of a gang or refuting any alleged gang affiliation.
Okay.
So that then negates my need for that subpoena, or I think for further argument from me.
Okay, and we'll get Ms. Piper to confirm that in a moment. I'm not remembering, and when I say remember, so the record is clear, from my review of the transcript of a trial that occurred before I was a judge, that there was a gang angle to this case, that it was not a gang prosecution. So what do gangs have to do with, it would be a parole situation, that not eligible for parole because post-incarceration, someone is thinking Mr. Singleton isn't reformed because he's engaged in gang activities within GDC facilities.
Yes, there's no allegation to my knowledge, and Mr. Armstrong can confirm or contradict this. There's no allegation of any type of gang involvement in this case. My concern is, as indicated by the court, post-conviction, post-sentence.
Okay. All right. So you subpoenaed GDC simply to get confirmation that either Sergeant Taylor or Cert Bess authored a document to confirm or deny. That's the scope of the subpoena?
Right. I didn't subpoena either person. I subpoenaed the GDC representative and also the name that was given to me, Ms. Gaines. Okay. For those documents. Okay. And then Ms. Piper and I have gone back and forth, and she has advised that neither one did author that document or documents. Okay. Not that the document doesn't exist, but that both, if they were called to testify, would say, I have never authored such a thing, said such a thing, thought such a thing. Trying to minimize the rabbit holes. Okay, got it. Was there anything else from GDC you were trying to get? Not pardons and paroles, but GDC? No. Okay. Mr. Armstrong, anything you want to add on that? Not that you were trying to get anything. I'm going to hear from Ms. Piper in a minute, but anything else in terms of context?
I have just searched the 4 volumes of the transcript for the word gang. It appears to have been used once by somebody testifying about why they might have moved to school. That was not my understanding of the case. And also, I don't believe that records of how well Mr. Singleton has been doing in prison are germane to a conviction. So I'd also say that they're relevant. Okay, got it. Ms. Piper, you've been listening very patiently, and thank you for making yourself available for this hearing and availing yourself of a virtual appearance. Tell me first where you plug into the Attorney General hierarchy, your role there, and then anything you want to say in response to what we heard from Mr. Hort.
Sure. Good morning, Your Honor. I am the Public Safety Section Chief, so our section represents all public safety agencies in the state, including Georgia Department of Corrections. I've been with the AG about 16 years. I know it shocks everyone, given my youth, but glad that we have the option of appearing virtually. So thank you, Your Honor. No, my client received the subpoena and was diligent search and even went above and beyond doing a diligent search and did some inquiries. And there is no documentation that would be responsive to the subpoena.
And did your search, if you are comfortable telling me, did your search involve someone interacting with a Sergeant Taylor or a Cert, C-E-R-T, Bess to seek out this document, or their involvement with such a document, or it was purely a documentary search of any and all records relating to Mr. Singleton's stay at GDC?
All the above.
All the above. Excellent. Well, thank you for verifying that and making that representation. Mr. Hort, anything else you want to get on the record concerning Ms. Piper's team's efforts to comply with your subpoena?
No, Your Honor. I would just ask that the legal department and Terry, T-E-R-R-I, Gaines, G-A-I-N-E-S, be excused from their subpoena. Okay, great. They are all excused from the subpoena. Let's pivot to pardons and paroles. I think, Ms. Piper, that falls within your purview as well. Look at that, one-stop shopping. So let's go there. What was it that you asked for, and what have you received, if anything, so we can frame this up? Thank you, Your Honor. And to be very clear, I asked for nothing for myself. I wanted this court to conduct an in-camera review of the documents received by pardon and parole as to Mr. Singleton. And it's not something per se that I am looking for it to be admissible in this case. I'm not asking this court to substitute its judgment for pardon and parole. I just want to ensure that pardon and parole was doing their job. And by that, I think it'd be fairly easy for this court to determine, i.e., if there were no documents, then that would raise a legitimate question. If there are documents that are going to pardon and parole, again, I'm not asking this court to exercise its own judgment, just to show that pardon and parole was facially doing their job. My concern is, and I certainly expect Ms. Piper to address this, is pardon and parole has only sent you a partial package of those documents. And again, I have no problems whatsoever that they're in camera, they're confidential. If there's anything this court feels is relevant to this case, they can be sealed. I have no problems with anything done to protect this state secret. My response is indicated in my argument, but again, I can't help but cite the United States versus Nixon.
Okay, but I'm maybe going to preempt Mr. Armstrong here a little bit. What does it have to do with the motion for new trial? Let's say hypothetically that Mr. Singleton ought to have received a parole hearing 14 years in. This case is old enough that I think maybe you were eligible for a parole hearing after 14 years in custody rather than 30 for a murder conviction.
He's had two.
Okay. And I learned that the one that was at 14 years, it was perfunctory in nature. Nope, it was a murder. We're not considering you right now. What would I have any authority to do? Question one, maybe more germane. What does that have to do with whether the trial, though those many years ago, was properly conducted?
It has to go with Mr. Singleton's status initially as a juvenile. And it is our argument that sending juveniles to life in prison can be a violation of the Eighth Amendment, and certainly is if that juvenile then will die in prison. And I have cited a case from Michigan to that effect, but I also submit to this court, even that first review after 14 years, if that was murder, end of story, I don't think that means the parole board is doing their job, especially with the second time, what happened there. And I guess my thought again is that this court is not the parole board, but I believe, number one, in our justice system. I may disagree with our appellate courts. I may disagree with the United States Supreme Court, but I think in today's world, the buck stops with the courts, and thank goodness that we do have courts. And that's why I cite United States versus Nixon. But this court has a right to look at those documents. Again, not looking for input from Mr. Armstrong or myself, not looking to make those documents per se public, but just to ensure that the parole board is doing their job. And I think if they are not, then that raises a question as to whether this sentence of life in prison to this juvenile was a violation of the Eighth Amendment.
Okay, so I think I'm following that. I know one of your arguments is that the sentence is unconstitutional, Eighth Amendment violation, and you're not alone in that juveniles being given a life sentence. The focus has been more life without parole sentences, that those are violative of the Eighth Amendment, absent some extreme circumstances, depending on each state. Some states you can't get that sentence, some you can. And if this is functionally life without parole because of the perfunctory way in which the parole board treats Mr. Singleton's attempts to be considered, then I need to think about the sentence differently, and it could become cruel and unusual.
Yes, and I would just add to that, the victim in this case was a deputy. And as such, by that, the killing of a law enforcement officer is something that nobody wants. And my concern there is that that was the end of the story, is the end of the story for the parole board. I would draw this court's attention that Mr. Singleton is now a wonderful person. The things that he has done, it kind of goes against the grain a little bit, but two of his colleagues are now dead. And maybe by going to prison for some period of time, maybe that has helped make him be the person that he is today.
Keep him alive.
Keep him alive. And he just is such a wonderful person right now that, credit goes to GDC for that. And I think in this day and age where they're getting so much criticism, it's proper for me to acknowledge that.
Okay.
But I guess my concern is he was not the shooter. You will see from the evidence that the co-defendant testified falsely at the trial.
Okay, you're getting out ahead of yourself, but I follow you. And I just want to make sure I'm not misremembering the facts. My understanding is that the gentleman who was killed was not a deputy, but a police officer. There's a difference. I mean, not a sheriff's, but it was an Atlanta police officer, maybe even a sergeant, but a police officer. But a deputy was in the mix because the murder weapon was stolen from a deputy sheriff, but not anyone involved in the crime. Am I remembering correctly?
Close.
Okay.
Yes, you are correct that the victim was a sergeant. I
Okay.
apologize for saying deputy. Mr. Armstrong raised in his response to our amended motion, Clayton County. So we have raised several issues in our reply to their response, pointing out that this so-called victim gave 3 different stories as to what he was doing, what was going on that day.
The Clayton victim,
Right.
not our police sergeant.
Yes, I'm sorry, the Clayton County victim.
Okay, I don't want to go down that rabbit hole now. I just want to make sure I was remembering. I'm removing Ms. Brady. That's another time she has caused problems. Okay.
Yes, and my concern is I don't want anybody to think because he robbed somebody in another county is doing life for that sentence. What we do here today doesn't matter that much.
Okay.
I just want the court to understand that there are legitimate questions as to what happened in Clayton County.
Okay. Not what we're litigating here, but I understand that. Okay. So, Mr. Armstrong, anything from you about pardons and parole?
Yes, Your Honor. I do not believe it is relevant to this case. He is legally eligible for parole. He's been up to the parole board twice. I have attended presentations by the parole board, including those that have been attended by Mr. Hort, where they have said that right now, those who were incarcerated under the old regime where you were parole eligible after 14 years are averaging to get out at 28 or so years. That's the average at this point in time. I'm not saying that that's nothing, but this court does not have a review of the parole board's decisions. And so it is a request without a purpose in that sense, because there is no basis that the court has to review the Board of Pardons and Paroles, and so it is an irrelevant issue. He is legally eligible for parole, and I hope that he is in fact the wonderful person that they say he is today. But that is something for the parole board to evaluate rather than this court.
Okay. And they would be working through someone who has not 1 but 2 life sentences, and that might make a parole decision more complicated for the parole board than someone with only 1 life sentence.
Correct.
Okay. All right. Ms. Piper, were you involved in the collection of the records that are in this very carefully sealed envelope?
Not in the collection, because the parole board zealously guards the privilege. So they delivered those directly to the court. They did not even come to my office. Okay. Those parole records, obviously, you know, you're aware parole is a matter of grace. There's a reason that the legislature chose to keep those documents confidential. And notwithstanding that, the parole board has provided all of the documentation with the exception of 3 very narrow categories that they feel are sacrosanct and don't even want to release to a judge. And that is the crime victim impact statements, which are given, you know, in confidentiality. The GCIC records, you know, there's a lot of limitations from NCIC and GCIC on those records. And then the actual votes of the board members. Those are the only 3 categories that have been withheld from the court. And we've provided and asked that you do an in-camera inspection of the balance of those records.
Got it. And those seem like very, very reasonable exclusions. In particular, the victim impact statements, those are extremely personal. The GCIC records, that we run into that always. That's nothing unique to pardons and paroles. Those are, they could get in trouble for disseminating those, and that's not what they need to do. And the actual votes, we know the overall vote was no. And so who voted in which way is a level of granularity that no one would need if in fact it's even appropriate to be wading through all this. But I've got the documents. I will review them in the, I don't mean this in a pejorative way, Mr. Hort, in the for what they're worth category. You're acknowledging that this is not in the lane in which I move. And while it's good that we have courts, I agree. Your action before me is give my client a new trial. It is not tell the parole board to do its job. That you haven't filed a mandamus, and I know how mandamus actions work when they're brought here against the parole board. But that may be something down the road that you choose to pursue. But I appreciate you linking it to what could, in effect, become a life without parole sentence, and that certainly raises Eighth Amendment questions. So I feel like I have what I need. Anything you want to add?
Yes. I would only indicate I agree with what Ms. Piper is saying so far as the victim statements. I would only ask that you be advised, did a victim or victims submit a statement? If there were no victim statements, I think that is something for this court to consider as to why the parole board did what they did. If there was, I'm not asking that you see them. I agree with the comments there, but I think it is important to know whether that did or did not happen.
So I'm not going to ask that question, because even that is a personal decision to choose not to submit something to the parole board. I am not going to. The deceased family, this is a difficult day for them as well, just like it is for Mr. Singleton. Something that was in their mind closed is open again, as it should be. It should have been dealt with, as we all believe, many, many, many years ago. The point is, I don't get to see, and I understand why I wouldn't get to see what they filed if they filed something. There may be another day where you want to fight that battle, but I'm not going to ask Ms. Piper, even if she knows. She may simply say, whenever we get something from pardons and parole, there are three things that won't be in there if they even exist. But I'm going to draw that line. Anything else?
Yes. I would also ask that the court receive the vote. The concern there is, as we all know, the parole board is appointed by the governor. The parole board is very conservative, and it is my understanding that they vote in sequence. So if there is a vote and they get to pick and choose who votes first, and there then are enough votes to say no, then there's not even any input from the other parole board members.
Okay. So I'm not going to ask for that, but I will gently push back. I think there are plenty of people who would say that the parole board is letting folks out real early. I sentence people to 10 years to serve, and they're out in 2. And I don't know that the average citizen would think that that's a conservative approach. I get why they're out in 2. There's a grid, and it's 10 years on a burglary. It's a nonviolent offense, and they have. So we don't need to engage on conservative, not conservative. The results are the results. They're not results your client likes. And I've got what Ms. Piper has explained. The parole board, not she, but the parole board has handed over, and I'm going to use that as my starting point. If I feel like there needs to be more, I will certainly engage with you and Mr. Armstrong and Ms. Piper. But I do agree with Mr. Armstrong that this is a little bit of a side mission. I understand why it's important to you and your client. But again, other than the potential hook of an Eighth Amendment violation, it's literally decade plus beyond the trial and can't have some retroactive effect on fair trial, not fair trial. Sentence, different question. So that's your toehold that is going to get me to open this envelope soon. Okay. Last thing.
Last comment. Parole board, state secrets. State bar, state secrets. GDC, state secrets. I think all of us should be concerned with entities that are allowed to keep state secrets and are not even subject to review or examination by a court in camera.
May I
Okay.
respond to that, Your Honor?
You may, and I think all we have is subpoenas here as opposed to court order. So we're not gonna, I don't think we'll be brought to the precipice of a court ordering and an agency saying no, and then we could have that fun conversation. I don't think that's where we are, but there are clearly some things you wanted to get through your subpoenas that exist as opposed to don't exist, i.e. the GDC document, that is frustrating to you, and I understand. Mr. Armstrong.
The reason these things exist and that they aren't reviewable is that a parole board member who's known to let people out early might feel like, if knowing that that's in public, would be less likely to send somebody home early. It would actually work against defendant's liberty interest. Similarly, the state bar, in keeping secret those things that are confidential as far as what is reported to them that don't amount to something that requires discipline, is something that protects the public and their ability to contact and make complaints about bar members, as well as bar members from being tarred by frivolous complaints. I've had clients, when I was a public defender, literally create out of whole cloth an entirely different set of facts that had no truth in it whatsoever. And if I was beholden to that, that would have tarnished my career based entirely off of lies if somebody had access to those things. The state bar was able to resolve it without having any kind of public because it was false. But basically, if you can go in and get every allegation that's ever made against a defense attorney, as the defense has done to a certain degree here, that's something that is going to improperly impinge upon individuals' reputations.
And might discourage people from reporting if they learn that the fact that they reported is going to be disclosed as well. I think we're going to be in a slightly different context with at least one of these situations because the attorney's deceased, but we'll talk about that in a moment. I want to let Ms. Piper be on her way if there's nothing else. Anything else other than railing against state secrets, Mr. Ford?
No, Your Honor, thank you.
All right, Ms. Piper, thank you so much for joining us and for the work you have been doing these many years for the public safety section. Maybe our paths will cross again soon. Take care.
Thank you.
All right, bye-bye. Okay, next up, State Bar. And who did you drag here from the State Bar?
That'd be me, Your Honor. Bill Neesmith, I'm the Deputy General from the State Bar, and this is Billy Herman.
All right, Mr. Neesmith, why don't you, just so you have a place to sit, you're not taking sides, but there's an empty seat next to Mr. Armstrong. Why don't you sit there and we'll have a conversation.
I'm really kind of uncomfortable standing at the podium.
Why don't you go to the podium? I'd like you to be where you are most comfortable. I don't think you're going to have to be there very long.
Thank you, Your Honor. It just doesn't feel right to me if I'm not standing. It's just,
Okay.
that's the way I do it.
Yep. I'm happy to adapt. So while you're standing there, Mr. Hort, tell me please why Mr. Neesmith is here.
Thank you, Your Honor. We have requested documentation from the State Bar with regards to the complaints filed against Mr. Gashard over the years. Mr. Armstrong and I learned today that there was one document that neither one of us had received, and that gives us some of this information, but it does not respond to prior grievances in years earlier.
Okay, and so we're clear on the record. You know this, Mr. Hort, but I want it to be clear from the beginning of the record we're building. Gary Gashard, Mr. Gashard, defense attorney, represented Mr. Singleton at his trial. So he was trial counsel, not appellate counsel.
Yes.
All right, he's deceased.
Yes.
And you have subpoenaed the State Bar to get basically the complaint file. I'm sure there's a formal name for it, but the complaint file, anytime anyone had contacted the State Bar to say, Mr. Gashard didn't do me right, didn't show up, I'm unhappy with, as opposed to commendations for Mr. Gashard. You asked for those kinds of things.
Yes, Your Honor.
And you received?
We received the order from the Supreme Court, and there was a document today that we learned about that neither myself or the state knew about and have seen. Mr. Smith was kind enough to show that to us this morning. So number one, I would certainly like that document. but also in conjunction with that, any documents over the years. And looking at it, Mr. Gishard receives suspensions in 2006, 2009, and a reprimand in 2010. So we know there were at least those 3 dates whereby there should have been or were grievances made against Mr. Gishard. If there were other ones, I would like to know about that. As the
All those dates are post this trial, though. Is that right? You said suspended in 06 and 09 and a reprimand in 2010?
Yes.
Okay. All right.
The wrinkle is we don't know when the grievances were filed, how long it took to go through the system, whether there were earlier grievances. As this court has pointed out, Mr. Gishard is deceased, and with all due respect to him, this is not going to put him in fear of any type of retribution or reprimand.
Okay.
All of our people that we're looking for to have made complaints, they are certainly not worried that somebody's going to be mad at them for making a complaint against Mr. Gishard.
Well, and uniquely for me so far, you don't have Mr. Gishard to ask questions about. Was this your first trial? Had there been trials before where you had this issue or not? You are unable to do that. And so the only way to get a sense of whether something like this was unique or the depth of the issue would be to better understand other work he'd done.
And Mr. Armstrong and myself will have this argument later, or we can do so now. And counsel may also want to join in this. But there is a question then as to the admissibility as to these other defendants that were wronged by Mr. Gishard.
Okay. So you received what should be a public document, the Supreme Court opinion saying, was it for one of the suspensions? It seems like there ought to be 3 Supreme Court, or at least 2, if he was suspended twice. I don't know that. 4 Supreme Court documents?
Yes.
Okay, I'm gonna let you navigate in just a minute. Anything else you want to add, Mr. Hort, about what it was you were trying to get?
And I'm sorry, I didn't hear what counsel said. We only have the Supreme Court opinion from 2010.
Okay, well, we may be able to remedy that. Can you spell your name for the record, please?
Sure. Last name?
Yes.
Is Nesmith.
Great. And your title at the State Bar?
I'm the Deputy General Counsel.
You're going to have a new boss soon, or you'll be your own boss soon. All right.
Now I have a new one.
Okay. All right. Mr. Nesmith, thank you for being here. And walk me through what you understand Mr. Hort was trying to get. Number 2, what you were able to provide. And then 3, if there are things you haven't provided, why it is you don't think they should either go to him or, in pardon and parole style, in camera to me.
Okay. So the rule that really covers this is Rule 4-221.1. And just sort of clear up.
When you say rule, that's a bar rule?
That's what I'm just about to clear up.
Okay.
And that is some of the things. We're not the state. We don't work for the state of Georgia.
Right.
And so there are not any state secrets here. We're an administrative arm of the Supreme Court.
Now, administrative secrets, those could be more pernicious. All right.
And then not only that is being an administrative arm and having those rules are promulgated by the Supreme Court of Georgia. They're not our rules at all. And that rule I cited, 4-221.1, prohibits us from either admitting or denying the existence of any grievance that is confidential. So we have different levels of discipline with the State Bar of Georgia. The first one, the lowest, is the formal letter of admonition. The second one used to be called the investigative panel reprimand. It's now called the State Disciplinary Board reprimand. Those are the 2 confidential levels of discipline that we have. After that, we have what used to be called a review panel reprimand, now called the State Disciplinary Review Board reprimand. And that is a public document. Then we have a public reprimand, which you, Your Honor, would deliver if it was in, somebody in your court. And then after that, we have suspensions, which could be a time or could be indefinite. And then, of course, we have disbarment. And so those are the levels.
Okay. And from public reprimand on up, that is a public result. That's what we see in the daily report every so often. Like, hey, these people were disciplined. And I say, do I recognize the name? Oh,
Yeah.
I know that guy. Okay. And that's either a reprimand, a suspension, or a disbarment.
That's right.
But you're helping me understand that there's a whole set of discipline that can occur that you might know about, but I'd never know because it's confidential.
Supreme Court doesn't know.
Supreme Court doesn't know. It doesn't leave the confines of the state bar.
That's correct.
Okay. You mentioned something about admitting or denying a confidential grievance.
Yeah.
So let's take a step back and talk about the grievance. So I'm calling the state bar. I'm fed up with attorney X. He's no good. He doesn't show up for court on time. His briefs have bad citations to law that's no longer good. Is that a confidential grievance, or I have to say, and by the way, don't tell attorney X that I'm the one who made this? What makes a grievance, or every grievance is confidential?
Okay. Well, first off, if a court calls us, then we tell the court, you've got to do one of two things. Provide us with an order where you sanction this attorney, or either fill out a grievance form.
Okay.
And if you fill out a grievance form, and I've got one, you can look at it, it has in great big letters at the top, confidential. And if you fill that out, now the lawyer that you are filing a grievance about is going to know it's you. And we tell you that up front.
So it's confidential to the rest of the world, but when your team reaches out to lawyer X to say, hey, you've got a problem, lawyer X, it's not a star chamber where what did I do? Don't worry, you're in trouble. Just trust me. They're presented with the grievance.
That's correct.
So it's confidential within your organization and the attorney against whom the complaint has been lodged, and the lodger, no one else knows about it.
That's correct.
Is there a non-confidential grievance form? I guess I could choose to go public with it, but that's on the person making the grievance.
There's no grievance that even if it's done, there's two ways we can create a grievance. One would be the person files it. You, me, anyone can file a grievance. And so that's just a person filing the grievance to state bar. The second way is based off of credible evidence. So credible evidence would be an order from the court. Maybe somebody a lawyer being hauled out from the courthouse, and we see it in the newspaper.
Right. A lawyer being arrested outside Red Martini Lounge.
Right. And right. And if that happens, then we take that information to the state disciplinary board and they institute a grievance.
Okay.
Now, that grievance would not be known by anybody, but of course the lawyer.
Sure. Okay. So 4-221.1 prohibits you, the state bar, anyone in the state bar, from admitting or denying that a grievance was brought, because grievances are confidential.
Unless they become public. In other words, it has gone to the point of being filed with the Supreme Court and then tried by a special master, and then there's a...
So how do you learn? So I read in the daily report that attorney X was suspended for 6 months, and there's an opinion and it lists all that stuff. And he took some client money, but he was suffering at the time. So they're mitigating circumstances. So suspension 6 months. It never says in there. And by the way, we learned about this because this person filed the grievance.
No.
How does so it's not that form, the grievance form isn't part of the public record. What is public is that this misdeed occurred and these are the consequences for that lawyer.
That's correct. When a grievance is filed, that grievance is then scanned by our grievance counsel. They look at it to decide whether or not, if all things were true, does it have merit? If so, they go to the lawyer and say, what's your response? Lawyer responds, grievance counsel reads it again, goes to the person who filed the grievance, said, would you like to rebut this? If they still are not comfortable that they should dismiss it outright, then it is sent to the state disciplinary board, to one of the members to investigate it.
Okay.
Then after it comes back, that's when a pleading is created. And that's where everything's public from there on. Everything before the pleading is done.
Oh, okay. Got it. And so the fact that an investigation results in a suspension doesn't make non-confidential all those things that were pre-pleading. Those remain under lock and key.
Yes.
And I wouldn't be able to say, well, look, the Supreme Court suspended this person for 6 months. Give me the whole file. I mean, I don't know, with an order maybe, but in general, the inquiring mind couldn't get the pre-pleading part of your file.
Correct.
Okay. And is that basically what Mr. Hort is asking for? Is it would be pre-pleading things, because it would be any grievance that's been filed, whether it materialized into a private admonition or a public suspension. He wants all the pre-pleading materials.
That is what my understanding.
Have you ever, how long have you been the Deputy General Counsel?
10 years.
In your decade of doing that, have you ever disclosed to anyone any of the pre-pleading materials?
Absolutely not.
Has a court ever ordered that you do that?
Absolutely not. As a matter of fact, I checked with another of my colleagues who just retired after 32 years, and she said it has never been done.
Okay. Either the disclosure or a court saying, hey, you have to hand this
That
over.
is correct.
How about an in-camera review?
Never had that either.
Okay.
Never been to court before.
Well, welcome.
It's always for this.
Okay. All right.
Yeah.
Well, Mr. Hort is an entrepreneur of sorts, so here you are. Mr. Hort, are there other things you want to, this is not a cross-examination, but it's helpful to hear from Mr. Neesmith. Are there things, now that we're together and having this conversation, well, let me ask you, Mr. Neesmith, before I pivot to the two lawyers, was there more you wanted to share with me? I now better understand why certain things haven't been provided to Mr. Hort. He seems to not have the same list of items that you think he should have. You think there should be 4 public documents? Because I only heard of 2 suspensions and 1 public reprimand. Why don't you make clear for the record what's out there?
There are 2 suspensions and 1 reinstatement.
Okay, and that's a public record as well.
That's these right here.
Okay.
And what these suspensions are for is just because he didn't answer the complaint in time.
Okay.
And then we don't have a default judgment, so we do this. And so then we also have in the matter of Gary Gilbert Bouchard, which is a per curiam opinion from the Supreme Court. And all this document does is order the reprimand. It doesn't write the reprimand, but I have the reprimand as well, which is part of the public record.
Who writes the reprimand?
In this case, it would have been the review panel.
Okay.
And so those I can provide. It's not a problem.
Is it pretty standard that when the Supreme Court orders a reprimand as the substance or part of the sanction for the lawyer's misconduct, that the review panel writes the reprimand? Or does the Supreme Court ever say, lawyer, you should write the reprimand, engage in some introspection, or complainant, you should write the reprimand? What's typical?
What's typical for a review panel reprimand is the review panel writes it themselves. I've never heard of anyone else ever writing it. We may actually participate in the writing of a public reprimand that goes to a Superior Court judge.
Okay. When you say we, meaning General Counsel's office?
Yes.
Okay.
That's correct.
And I was focused on the public reprimand. So the public reprimands, you said you may. Who typically authors the public reprimands?
The ones that, well, I mean, we generally,
If it's going to a court.
yeah, draft the reprimand and we'll send it to the Superior Court judge.
Okay. Does the attorney being disciplined have any input on the reprimand? Like, oh, that seems a little rough. Could you use a different adjective than crummy?
You know, if somebody has an issue with a particular word, I'd certainly listen to them. But formally, no, they don't have any right to
Okay.
input in that.
Got it.
But the review panel is like an appellate part, and so we have to keep arm's length from them. So that's why they write their own.
Okay, got it. I was on a tangent. So it sounds like you've got a few other documents maybe Mr. Hort hasn't seen. They're not going to be what he was looking for, which would be the complaints, but it might be if he didn't obtain what the actual reprimand said.
I mean, all I have is this that I can provide.
Okay. What was it you think you showed him this morning that was new to him? One of those things? Okay,
I'm
one
not
of
sure
those.
if I showed him this. He did read this.
I can tell you, Your Honor, there's 4 documents that he has. One is what you see on the Georgia Bar website, which is what the Supreme Court's per curiam opinion is.
Okay.
The other matters are the public reprimand itself, which is in Mr. Nesmith's hand is attached to that Supreme Court opinion.
Okay.
And then there was another document that basically said, you failed to respond, and so we're suspending you, and then we're reinstating you after that.
Okay.
And that was shown to us just before. Can I ask a question?
Yeah.
You indicated that from the pleadings forward, it's public. How would Mr. Hort or I get the pleadings for the case that went before the Supreme Court?
From the Supreme Court. They're filed there.
Okay.
So it's in the docket. It would be docket A1234.
Correct.
Okay.
And it's actually provided on here.
The case number. Okay.
You could go and search this name and find anything that had been filed at the Supreme Court.
Okay.
Your Honor, if I may interrupt,
Question or comment?
both.
Okay, start with the question, because he can sit down when we get to comments.
Okay, as a former judge, I would ask for counsel's name so your court recorder knows who was speaking earlier.
Yeah, I should have done it. We heard it briefly before, but there was a gentleman who weighed in on who authors the public reprimands, and the overall answer was the general counsel's office does. But if you could spell your last name.
Yes, sir. It's Hernberg, Hearn, B as in boy, URG.
Great, thank you, sir.
Number two, would it be possible, does the court have someone that can make a copy of that reprimand from Mr. Armstrong and myself right now?
Yes, no one's going to leave empty-handed. That way, when Mr. Nesmith and Mr. Hernberg leave, they know they're done, because we'll make copies. I'm assuming it's okay to make copies of those. Okay.
That's why I brought them.
We will do that.
Comment question number three. I have tried to find things on the Supreme Court website, but if you don't have the number or the name, it's impossible.
So how about this? I'm going to see if Mr. Armstrong can find it. If he can't, there's an issue with the system, and we know who to go to, and that'll be Mr. Nesmith. But if Mr. Armstrong can get it, he'll get you a copy.
So the number is the one with the Y. That's on the face for a curiam opinion that you have.
Yes.
That's the case number for the Supreme Court.
He seemed to be talking about other cases.
No, I said if there were other cases. The
Right.
only public case that I'm aware of is this.
And that's what I'm saying is we can't search other cases because we don't know the case number and we don't know who the defendant was that made the complaint.
So two things. One, you can search Gashard. You could type that in, and anything that's public ought to come up. Two, Mr. Nesmith has stated as an officer of the court, there is only one that made it all the way to the Supreme Court. And that is, let's just get the case number on the record.
Okay. S as in Sam, 10, Y as in Yankee, 0388.
Okay. And Y's, those are all the state bars. Z is JQC, is Y state bar?
Yes, Your Honor.
Yeah. Okay. So you got that number. If you type that into, it's not called Pacer.
No.
Before you get too far down that road, the Supreme Court documents, their opinions are available online for more recent cases. To see the filings for especially cases in 2010, you'll have to go to the clerk's office at the Nathan Deal Justice Center.
That's why we've got the investigator. Perfect job.
But it's not something that I think you can easily access by the computer. You'd have to go to the clerk's office.
Okay. But we've got that magic number now. Ma'am, I would like, or sir, I would like S10Y 1, 2, 3, 4. And you know how to find me. If you are thwarted in that attempt to get the pleadings there, and actually it's Mr. Armstrong who asked for it. If he's thwarted, let me know. And I can go to the deal center. I bet they'll give it to me.
I appreciate the court's suggestion and thank you, Mr. Armstrong, for trying first to see what he can get. And then if he can't, I certainly will use my investigator. And I assume by that the court is willing to provide additional funding for him.
The expense of getting the thing, I may make you do it. And if we had to pay him his hourly rate, we'll just have you go get them. We'll figure out a way to get them. And yes, your investigator will be compensated.
Thank you.
All right. Did you have anything else? You had said 2 and we were on number 3 for Mr. Nesmith.
I would ask Mr. Nesmith, when things go from their department to the Supreme Court or to the Superior Court, are there documents that are sent with that? You know, the grievance itself, supporting documentation, anything that might indicate who this person is or what the grievance was?
Well, first off, let me just want to clear one thing up. There's not going to be the grievant versus the lawyer. It's not how it's going to be styled.
It's in re.
That's right.
Bad lawyer.
That's right. So that's how you would find it. And then other than that, what we do is whatever we receive, we determine what we're going to use as evidence when we go in front of a special master. And yes, the special master, those pleadings will have the grievance name in there.
Okay. But those aren't the things that go into the Supreme Court docket, or that would be in the Supreme Court docket?
That would be in the Supreme Court docket.
Okay. So all the more reason to get into that docket, which is publicly available in the Deal Justice Center. Anything else for Mr. Neesmith?
Yes, I guess my question then would be, would it be possible then for Mr. Neesmith to send us those documents and save Mr. Armstrong from walking across the street, save me from the parking cost, the time cost, and just
I think the right way to handle this is to get them from the Supreme Court docket rather than make it a state bar thing, because it's not the state bar's docket. It would be what's in the Supreme Court docket. I think it's a cleaner line of demarcation. The state bar is handing over what they hand over, which is nothing, over 32 years of nothing, because if it's pre-pleadings, those aren't disclosed, administrative secrets. If it is pleading and beyond, then it's in the Supreme Court docket, and we can figure out a way to make it relatively non-burdensome for you.
and I would still ask for copies of any grievances that were filed against Mr. Gashard.
I understand what you haven't you've made that request, and Mr. Neesmith is here today explaining why the state bar has declined to produce those pursuant to your subpoena. I thought that's why we were together today.
I wasn't sure if that argument was still ongoing or if I had reached my breaking point.
Well, I can't answer the latter. It's still ongoing, though. Anything else for Mr. Neesmith from you?
Yes, again, I would cite United States versus Nixon. I mean, that case says it all, that not even the president of the United States has this right to confidentiality when the courts are involved. And again, if Mr. Neesmith wants to send these documents to the court, for the court to make that initial determination whether there are defendants' names that I can then contact to see what happened in their case, I don't have a problem with that. I would indicate to the court, and again, I don't know if you want to have this argument now or later, as to why this information is relevant.
So later, so Mr. Neesmith's not standing at the podium while you do it. I understand why it's relevant, and I'll hear why you think it's relevant. And certainly Mr. Armstrong will have a chance to respond, and then I'll engage on why we have Rule 404B and how it applies to everyone, including deceased defense attorneys. But we'll get there, not on Mr. Neesmith's time. Mr. Armstrong, did you have anything else for Mr. Neesmith?
No, Your Honor.
All right. If you could get me those documents, I'm going to make copies of them. So we're going to take a quick break. This can be our morning break. It's a little earlier than I wanted to take the break, but I want to get you on your way. And we'll make copies of, I assume you're okay if we make copies. Those are all public documents.
Absolutely.
Not from your vault.
No.
Okay. Anything else you want to add, sir?
No, yeah.
All right. Thank you for being here. Appreciate it.
Approach.
Yes. Thanks. Actually, this won't be a long break because I actually have someone back there who can make copies. So we will still take a morning break, but that'll be more like 20, 25 minutes. Is that all right? You guys are good to go, though. Thank you for coming here from the State Bar. Thank you.
I'm just trying to determine now how many witnesses I want to still try to keep here this morning.
Okay.
We do still have some additional arguments, but
This is your morning. So what will we do next?
we've got an argument that I raised in my reply to the state's response.
Hold on one second. I'm just gonna have someone come grab this. There were things you wanted to argue before you put up witnesses.
I was going to ask the court to make a determination prior to putting up witnesses, I think from the state's response, that there is sufficient evidence for this court to grant the amended motion for a new trial without having to take all of that testimony. Okay, well, we should talk about that. So why don't we do that?
How many we need? Oh, he left. So I guess this is my copy. So we'll make 2 copies of everything, one for Mr. Hort, one for Mr. Armstrong. Please. Thank you. All right. So why don't we have that conversation?
Okay. I don't know if the court wanted still a quick recess or if you're good.
No, I didn't want it. We needed to make those copies.
And I think this time I am going to stand up at the podium.
Great.
Your Honor, if this involves argument that people are going to testify about, I would ask that those witnesses would be excused from the courtroom.
Okay. Why don't we do that so that you aren't framing issues for them?
Judge, you knew that I would have a response to that.
Well, you can give me your response and then you're going to need to have these people step outside, but I'll hear your response.
We'll see. This happened back in 2000. It's been 20 plus years. The trial attorney is deceased. A co-defendant is deceased, and one of the witnesses is deceased. Other witnesses have memory issues. One of the witnesses, I got a doctor, the appellate attorney from his psychiatrist, saying that he's been suffering depression and anxiety and has been treating him from 2023 and should not then be a witness. Long story short, I don't know what you remember of 20 years ago, but my memory sometimes needs prodding. And I think by allowing those witnesses to be in court to hear what the discussion is about, that helps to make their testimony relevant. Mr. Armstrong will, of course, have the right to cross-examine those witnesses and point out where you're sitting right there when your attorney told you what to say, whatever he wants. But I think in the unique circumstances here with our inability to call the trial attorney, the appellate attorney, other people that have died or have memory issues, that it would be reasonable to allow those people to remain in the courtroom or on Zoom throughout this hearing.
Okay. One question, Mr. Greenberg's not available, the appellate attorney?
Yes, he's the one I got the letter from the psychiatrist, and I can go ahead and offer that.
You don't need to yet, but so that's why you're saying he won't be.
Yep. It is currently my professional opinion that him appearing in court would be detrimental to his mental health. He's been under my psychiatric care since April of 2023. He's been treated for depression and anxiety.
Okay. So I appreciate your perspective on that, but I think you made Mr. Armstrong's argument for him. And much like he would be free, Mr. Armstrong, to say, well, of course you said that. You just heard Mr. Hurt say that. You've had an opportunity, hopefully, to interact with these witnesses to help refresh their recollections as you've done your very, very thorough investigation into what happened and didn't happen and should have happened at the trial. And in some ways, more importantly, what's been happening since then. So if you have anyone in the courtroom who you plan to call as a witness, those people should go outside. And if there's anyone online other than Ms. Brady, who I had to remove, we'll put them in the waiting room. And I promise to get them out of the waiting room just as soon as you're done.
If I may ask, the state has not indicated any witnesses they intend on calling, so I'm assuming they are not calling any witnesses?
Well, I'm going to get to Mr. Armstrong because turnabout is fair play. He'd need to do the same. But is there anyone, thank you so much, who is online? There's a Paris, and obviously Ware State Prison can stay on. That's your client. But that's it. Ms. Rolak is victim witness advocate, so she can stay on. I don't know who Paris is.
And Niles?
That would be this woman right here.
Oh. Paris is a colleague. They go between Mr. Singleton and myself. She is not listed as a witness.
Okay, and Paris can stay right there. You'll get him? Great. They can just be anywhere outside. Yeah, and they can all come back in a moment, probably. We'll see how it plays out. Thank you.
And I do plan on calling Mr. League. He's my investigator.
It's okay. He can stay here too.
Your Honor, I just wanted to see if the court could check in with Ware State because while Mr. Hort was talking just before the court told the witnesses to excuse themselves from the courtroom, there was another person on the screen and it looked like they might be resolving some technical difficulty. And so I just wanted to make sure that everything is still fine at Ware State.
Okay. We're getting a thumbs up. Good.
Okay.
Okay,
Just
thank
to make
you.
sure.
Excellent. Thank you, Ware State. You guys are doing a great job. All right, Mr. Hort.
Yes, I'm just looking. I did not see any other witnesses.
All right.
Okay, thank you. First of all, as a administrative matter, we would offer defendants proposed exhibits A through O. The same were attached to the amended motion for new trial. N and O were attached to our reply to the state's response.
Okay.
The state objects to the admission of evidence wholesale by an attorney with nothing else to authenticate. I need the witnesses to testify.
Okay. I've looked at A through O in reviewing pleadings, but that was a little while ago. So I guess you'll need to wait for the appropriate witnesses. If you've got witnesses, if you think you need them, maybe they're self-authenticating, but Mr. Armstrong has put a barrier in the way of wholesale admission of exhibits through an attorney. You can still make your argument.
Thank you. I will. I just was going to attach this to Mr. Armstrong's state response. And I'm sorry, we do or do not have the victim's family present?
That's a question for Mr.
Okay.
Armstrong.
Ms. Rolack got the Zoom information, and I'm worried that maybe the person who was excluded was the victim's family member.
Well, there was a Ms. Brady, and she, yeah, I'm happy if Ms. Rolack can connect with her and let her know she's got to stay on mute, then she can come back in. She'll have to dial in a different way.
Don't know that Ms. Brady was.
Okay. Well, Mr. Singleton has his hand up. I think Ms. Brady may have been someone with Mr. Singleton. Yep. Okay. So I apologize about that, Mr. Ware, but she wasn't able to make the Zoom work well for the rest of us.
I just want to say I certainly have no objection to their being in the courtroom or participating via Zoom. I just wanted to make sure, again, they understand that I made a mistake when I referred to the sergeant as a deputy. I apologize. I also apologize. And this is not intended to in any way minimize his tragic death.
Okay, that's helpful. No one should take your advocacy for Mr. Singleton in that way.
Okay, so Your Honor, in our reply, we asked the court to rule without the necessity of even taking testimony, and we certainly can. But I think from the state's response, there are many issues that they are not contesting that would give this court grounds to award a new trial to Mr. Singleton. And I'm going to go through those grounds. First of all, I know Mr. Armstrong. He's a good person. It just shocked, amazed me. One, today, all the exhibits that were tied into our amended motion for new trial, and the reply that he wants me to go through the process of bringing in witnesses. Fine, I can do that, but it still surprises me. Even more so as the court looks at the state response, Mr. Armstrong, name calling, personal comments. He knows I'm a prior judge. He knows I was an assistant prosecutor. Yet he says the affidavit that my investigator got from Mr. Waters, signed by someone purporting to be Waters. And I'm sorry, to me, that is outrageous as a former judge, as a lawyer, as a citizen, that an assistant prosecutor who knows better would say something like that. It's an uncalled for personal attack. It violates Rule 3.8. Mr. Armstrong knows Waters refused to testify in the Clayton County case, telling the court because I don't feel right testifying. He knows that Waters wrote a letter 20-some years later expressing his remorse. That's Exhibit B. And just for him to say that Exhibit C is something purportedly done either by me or by Mr. Alig, my investigator, to me is just that in and of itself, number one, says everything. You've been doing these cases long enough. We all have. And you know that when somebody starts attacking the other side, when they make it personal, it's because they don't have a case. And I think the court can look through the response by the state and see that all of those personal attacks were uncalled for. And there, as such, they not only impugn his integrity, but also impugns his belief in the state's case. Now, going to the state's response. Mr. Armstrong argues on page 10 that the affidavit strongly and directly implicates Singleton. Yet,
And you're referring to Mr. Waters' affidavit?
yes,
Okay.
and I'm sorry, that I believe is the only affidavit we have, but yes, Mr. Waters.
That's what I thought as well, but I just want to be clear.
So page 10, he argues that Mr. Waters' affidavit strongly and directly implicates Mr. Singleton. Yet in the affidavit, Waters admits that Leslie did not plan the robbery, supply the gloves, the mask. It was not all Leslie's doing. Waters admits it was his plan to rob Bacardi, and that was the drug person where they were initially, whose house they were going to. His plan to steal the car, the gloves and mask were his gloves and mask. He had guns. He had bought, traded, and been using guns to rob drug dealers. To me, that in and of itself, in conjunction with his testimony in Clayton County, in conjunction with his affidavit, in conjunction with this letter, Waters provided false testimony at trial. And I don't think the state is denying that. They just say that, so what? It still implicates him. And I would make reference to Giglio, Giglio versus United States, 405 US 150. A new trial is required if the false testimony could, in any reasonable likelihood, have affected the judgment of the jury. Any reasonable likelihood, not beyond a reasonable doubt, not for all intents and purposes, just whether there's any reasonable likelihood the false testimony could have affected the judgment of the jury. Now, notwithstanding request, no transcript has been provided of any juvenile court hearing or a Jackson Dental hearing. The juvenile court did not respond to our request. We assert that he has been denied his right to pursue a motion for a new trial by the failure to produce those transcripts. Or if there was not a Jackson Dental hearing, trial counsel is ineffective for not pursuing a Jackson Dental hearing. And the state, in their response, doesn't necessarily refute or dispute any of that.
So a statement that Mr. Singleton gave to law enforcement was used at his trial?
Yes.
Okay. And you are turning to juvenile court for the production of a Jackson Dental hearing?
No, my client from day one tells me that he started off in juvenile court. So I requested of juvenile court transcripts, anything.
Okay. And you've received nothing from juvenile
No,
court?
not even a response. I assume Mr. Armstrong did likewise because he does his job. And even if a response would have been like Ms. Piper did today, there was no hearing, then at least I would have had a response. The de novo, I believe, should have taken place in the Superior Court.
So there should have been this is so old, I don't know if SB 440 was around then, but there's some bind over proceeding where a neutral and detached magistrate, and I think historically has been a magistrate judge, considers whether Mr. Singleton's case may properly be prosecuted as an adult felony case. Not that he is an adult, but that he can move through the adult felony track. And so that should have happened. That wouldn't have been a juvenile court proceeding, though.
And that's the question I asked my client. He just swears up and down it was juvenile, but again, at age 16, he might have thought they're all the same.
Okay.
I would note that in the AJC article, image 7 of 8 shows Mr. Singleton in front of a, as he described it, a black male judge. And asking Ms. Gross, she says that was Judge Eddie.
So let's not make the reporter a witness here.
I'm sorry.
But
that might have
we'll
been
figure out.
That might have been the judge you were talking about that might have done that Jackson Dental hearing.
Well, it would have been an SB 440
440
hearing.
Yeah.
If there were a Jackson Dental, that would have happened after the case was indicted and assigned to a superior court judge, which would be Judge Downs, and it would be in the docket that I know you have done your best to pour over.
And Mr. Armstrong can agree or disagree, but there is confusion in what we can see online with Odyssey and otherwise. On the one hand, it appears that there was one. On the other hand, there was not one. He's asked, I've asked, and neither one of us have received any transcripts for any Jackson Dental.
Okay.
So my argument there is, one, we should have those transcripts. Two, if we didn't, Mr. Gishard was ineffective for not pursuing that Jackson Dental, and I'll go in that more in depth later.
Right. So right now, I need you to stay focused on why you don't need to call all these witnesses.
Yes, I'm sorry. The state's response does not object, submit facts or law to counter the following arguments that trial counsel provided ineffective assistance of counsel. One, as alleged, trial counsel never sat down with this just turned 16-year-old juvenile charged with murder to discuss the case. Two, trial counsel failed to give defendant the opportunity to review his statement prior to his testimony. Three, trial counsel failed to cross-examine the state firearms and ballistic witnesses, Sarah Cheek, CHEEK, forensic specialist, G. Patterson, Fulton County detective, Peter McFarland, MC capital FARLANE, special agent FBI, Allison ALLYSON Vance, V as in Victor, ANCE, forensic DNA analyst, GBI, Christopher Robinson, firearms examiner. The state's response does not object, submit facts or law to counter those arguments that was ineffective assistance of counsel. And the court, we will be presenting testimony that the ballistics was very important. It would have shown where my client was when he was shot by Sergeant, where my client was when Waters shot the Sergeant. And by that, it may have justified an abandonment instruction. It may have justified a not guilty on felony or murder, because my client was no longer in the car, no longer per se at the scene when Waters shot the sergeant, waiting until the sergeant had run out of bullets and then shooting him. The state's response does not submit any argument, facts, or law to counter defendant's argument that trial counsel provided ineffective assistance of counsel by failing to investigate and pursue matters relating to the credibility of Detective Frank Martin. Why was that important? The state's response ignores Leslie's status as a 16-year-old juvenile desperately trying to get his mother out of jail. A motion to suppress was warranted and justified by Detective Martin's acknowledgement of the promise conveyed to Leslie that in return for his statement, they would do everything in our power to get her out of jail. And I make reference to the Clayton County jury transcript, page 132, Defendant Exhibit M, proposed Exhibit M. Applicable at the time, Georgia law required confessions of juveniles must be scanned with more care and received with greater caution than those of adults. Crawford with a C versus State 240 Georgia 321. The state does not respond to the expressed concern that the state's assistant attorney and law enforcement obtained multiple unrecorded statements from co-defendant Waters, that Waters' trial counsel was not present during those statements or during his client's testimony at the Fulton County trial or at the Clayton County trial, and was never even advised of the corresponding trial dates when his client testified in Fulton and Clayton County. The state's response does not submit any argument, facts, or law to counter defendant's argument that the trial counsel failed to investigate, question, or bring up anything dealing with the integrity of law enforcement officers. The victim being an off-duty police officer, the officer's actions in response to a fellow law enforcement officer being murdered were a legitimate avenue of investigation. Defendant Exhibit B. After turning himself in, I expect the testimony will show, and we've so cited, Mr. Singleton was threatened by Atlanta police officers. He was pillowcased behind Kroger Road off Godby Road by two officers to force him to identify his co-defendants, attacked in Metro RYDC by administration and staff on two separate occasions, and jumped by four officers in Clayton County. All again because the victim in this case was an off-duty police officer. The state's response argues that trial counsel was not deficient for making the objections now new counsel says he would have made, that these claims are exceedingly, I'm going to mispronounce this, picayune, P-I-C-A-Y-U-N-E, and are without merit. And again, the small-minded comments, the personal attacks by counsel amazes me. Merriam-Webster defines pickaninny as being paltry, petty, small-minded. Other than these personal remarks and the all-inclusive trial strategy, which this court has heard, as has every appellate court in this country, the state has no answer to trial counsel objecting 3 times during the state's case in a 2-day trial and not objecting 314 times to leading and asked and answered questions. And I recognize some of those are minor questions and answers, but again, cut it in half if you wish, 170 something. Still, not objecting allows the state to control the narrative, control the questions, control the answers. The state does acknowledge that asking the detective whether Waters' second statement was the truth of what happened was objectionable. Again, there's another ground for this court to take and use to grant the motion for a new trial without taking testimony. I refer to response page 22, but that the decision not to object was a reasonable trial strategy. And Singleton's case was not prejudiced by it, and this was not ineffective assistance of counsel, referring to the response page 22-23. Mr. Singleton points out that Waters was a critical state witness and a police officer, as this court knows, as everyone sitting here knows, vouching for testimony is everything. When improper bolstering has occurred, the court must consider factors such as whether the case was based primarily on bolstered testimony. Yes, Mr. Waters. And if the improper bolstering added critical weight to the testimony. Yes. When a police officer says that a co-defendant that...
Hold on 1 second. Really? That's weird. Hold on 1 sec. Thank you. All better. Thank you.
I won't ask for them to replay what I said.
Good.
Anyway, when a police officer tells that a testifying co-defendant is testifying as to the truth, there's no way anybody could say that's harmless error, that it's minor, that it's no big deal. The trial attorney should have objected, should have asked for a mistrial. The state's response does not submit any facts or law to counter defendant's argument that trial counsel provided ineffective assistance of counsel by failing to exercise or utilize an expert witness. And I reference the response, page 23.
What defense ought to have been raised in the case that wasn't? It doesn't sound like it was a good set of facts for Mr. Singleton. And so if one concedes for, because I want to get to the substance of your motion, if that's where we need to get, i.e. having witnesses testify, et cetera. And as I wrestle with the record that was made during the trial, you make a good point. 3 objections and maybe there could have been 300. In a 2-day trial, an attorney who made 300 objections might be deemed ineffective. The jury would have not liked that attorney. And some of those objections might have been picayune. Sometimes leading questions are technically leading, but you got to the scene in the middle of the day, correct? That's a leading question, but the timing of the crime may be utterly immaterial in the case. So my pushback right now at this phase, where you are understandably trying to short circuit some of the hearing, because maybe we could jump to, let's just grant a new trial. Writ large, what could an attorney have done for Mr. Singleton? Not writ little, hey, object here and do this, and the detective maybe shouldn't have been vouching for someone's testimony, but it doesn't sound like it was a good case for Mr. Singleton. At best, maybe abandonment. I don't know that I've ever charged abandonment because he got shot. That's why he was no longer part of the case. He was in the car. I mean, it's not an alibi case. It's not, maybe it's a sympathy case. It's a merely present, but it doesn't sound like there's a way to reasonably construe it as merely present. Minorly participating, yes, but that's That's the stringency of felony murder. If you're in all for one for all, and your co-defendant shoots someone and that person dies, you could well be found guilty through felony murder or murder. Who knows? So I want to push back a little because I think we're going to need to have you present the things you're prepared to present because of the set of facts that Mr. Singleton was up against, regardless of who his lawyer was. I guess put differently, how is the prejudice such that all the death by 1,000 cuts, and some of them weren't cuts, they were maybe clubs to the head of things that didn't happen but should have happened. If those things had happened, different outcome? Obviously, we're speculating, but it's not like there was a way to keep Waters's testimony out, or that suddenly there's that witness who said, no, Mr. Singleton was with me in Louisiana.
2 points. First, I have done appeals with this court before, and I've seen you, one, as a trial judge, tell the prosecutor, the state's attorney, stop asking leading questions. So that could have happened. Number two, and you've seen it as a judge, I've seen it as a judge. Mr. Gouchard would, Your Honor, Mr. Gouchard, Your Honor, may we approach the bench a minute? Or during a recess, Your Honor, may I ask something? Your Honor, would you direct the state's attorney to stop asking leading questions? I get it that some are appropriate, as you have indicated, but would you direct the state not to do that? And I've also seen it both ways. You're right. Nonstop objecting, the jury doesn't like that. But I also have seen where the state objects, maybe not nonstop, but a whole lot. And that doesn't seem to hurt. And to me, the same argument is for the defense. If you make legitimate objections, the jury is going to sit there, yeah, well, I'd like to hear the witness testify, not just the district attorney.
Yeah.
So I agree, not to do it 300 and some times, but I think you can do it reasonably. And I think you also can ask at the bench or at recess to have the state stop asking these leading questions.
Sure, and that was sort of my sideline point. The larger point was what if we're going to short circuit this, which I don't think we're going to be able to do, unfortunately for you and Mr. Singleton. You need to show me that that what you found that would have made a different outcome if the lawyer hadn't been deficient in the ways that you've identified.
Yes, and hopefully I will not leave anything out. And that's the problem a little bit, and it's certainly not your fault, but you have what you have seen in the transcripts, what you have read, and yeah, it sounds like, wow, you got nothing else, a party to a crime, a co-conspirator. And it may not be the right thing, but it is Georgia law, and it doesn't take much.
Right, and here we are.
So my counter to that is the false testimony by Waters. I think, and I've not argued it here because it's not really in the state's response, that from the testimony itself, you can tell that it was false. But with this affidavit, with Waters saying that Leslie did not plan the robbery, that takes away one of the arguments by the state, did not supply the gloves or mask, takes another one away, it was not Leslie's doing. Waters saying it was his plan to steal the car, the gloves and mask were his. He's had guns before. So that takes away the prejudicial impact of the state's case. You take all that away, and what do you have? You have that at some point Leslie got this gun and he gave it to Waters. But you don't have any proof that says this was for them to go and kill this deputy or anything that makes him a party to the crime here.
But doesn't Waters still say Leslie was there, he got in the driver's seat, he said, dang, I can't drive this car, it's a standard. I mean, shaving away parts that aren't consistent with his trial testimony, and again, we're dealing with an affidavit as opposed to Mr. Waters right here, but shaving those away, isn't there still, oh yeah, we were all there, we were taking this car, and unfortunately someone died as a result of the carjacking. That is still felony murder.
That's my second point.
Okay, let's get to number two.
We're talking about a 16-year-old juvenile. And yes, if necessary, I will have testimony in that regards. But let's just right now it's a 16-year-old juvenile that, as Ms. Blaylock said, slowly jogs up to the car, gets in. So he's in the car. The car goes in neutral. We assume that it was Mr. Singleton that did that. Does that then make him a party to anything, or does that something that, wow, okay, why did he do that? So anyway, in the car.
In a car that is not his.
Right.
Right. A car they've taken at gunpoint.
Yep.
Okay.
Well, they have taken a gunpoint.
Well, how,
Mr. Waters took at gunpoint.
and just coincidentally, Mr. Singleton walked up and said, here is now an ownerless car. I'm gonna get in the driver's seat, and shift it into neutral.
I don't mean to say anything derogatory to the court. Maybe the court doesn't have any kids. But kids do that all the time.
I have a 17-year-old kid, and he has managed not to jump into the driver's seat of a car that was just taken at gunpoint.
Yep. And I'm going to guess that your 17-year-old had a very different life than this 16-year-old. Anyway, my point is, I don't know that you can necessarily jump to party to the crime or co-conspirator, or if this is mere presence. I think you need more. I think you need to look at what happened then and look at what the evidence shows. And that's what's so important. And that's what, again, the state does not contest. Ballistic evidence showed, and you don't need to be an expert, although an expert certainly would have been helpful. Ballistic evidence showed that Leslie was shot by the sergeant as he was trying to exit the vehicle.
Exit the vehicle, meaning the sergeant's vehicle?
Yes.
Okay, so someone had entered his vehicle that they've been at gunpoint told to get out of and get away from.
Yep.
Okay, and you don't have any evidence that Mr. Singleton was unaware that Mr. Waters had extracted someone from the car at gunpoint?
But do they have evidence that he did?
I'm asking, you tell me what the record is.
No, that's a very good point.
Okay.
But let's assume your scenario, and probably Mr. Armstrong's. Assuming that he knew that Mr. Waters was doing something he shouldn't do, that he was going to take this car by force, that he had a gun on both the sergeant and the nurse, okay? Still, he hops into the car. Waters gives him the cell phone. What does he do with it? He throws it on the ground. Now, does that indicate he's a party to the crime, or does that indicate mere presence? That's the evidence. But again, what is so important is in what happens and what could be established just by looking at the evidence, or again, if you had an expert, or if you did a cross-examination. Leslie was exiting the car when he was shot by the sergeant. And then the ballistics shows that Leslie was not in the car, that he was gone when Waters shot the sergeant.
Gone means what?
Gone means that he had left whatever was going on.
I don't want to dive too deeply now because we're going to need witnesses, but how do ballistics show if Mr. Singleton was standing on the roof of the car, was lying down next to the car, or got back? Ballistics are shell casings, and no one's saying Mr. Singleton was firing a gun. So how do ballistics say anything about whether he was right next to Waters saying, shoot the guy in the chest, that's more effective than shooting in the leg?
And I apologize, I should have said the forensic evidence. The forensic evidence shows where the bullets were in the car. It also shows where the blood was in the car. And by that, it's not that hard, and thank goodness Mr. League is better at it than me, was able to clearly show where Leslie was, that he was exiting the vehicle when shot, and that he had left the vehicle when Waters shot the sergeant. Where was he? Again, it's a testimony type of thing, but the court asked, he was passed out. He'd been shot and he's passed out on the ground. The next thing he knows is he's being helped up by Waters. Okay.
I just want to clarify, you had been saying he left, and if there were, you suddenly had evidence that he was in East Point, as in he left, as opposed to in the midst of the carjacking, I got shot, and so I left the scene because I passed out, as in I lay down next to the car. That is factually very different.
And I expect, and Mr. Armstrong can correct me if I'm wrong, there is no evidence that shows what the court thought may be possible, that he's still standing right there saying, kill him, shoot him, doing anything. He was gone.
Gone as in he was not actively participating anymore.
Yes,
Okay,
if he ever was actively participating.
okay.
Don't you love these arguments that you and I have?
I don't know about love, but here we are. All right, anything else you want to add?
I've got more on the response.
Well, but what I don't want to do is have you respond to the response. You can do that in writing. You told me that you felt there was a reason for us to basically stop now and say motion for new trial granted.
Yes.
I don't feel like we're there.
Doesn't that happen if the state's not even contesting?
Well, I haven't heard anything from Mr. Armstrong. I've watched him move his arms like this a number of times as you've been saying things.
That's why.
Well, so why don't you list a few more things that you feel the state is not contesting, and then Mr. Armstrong can say we are, or we don't need to, because that alone wouldn't be a basis for a motion to grant a motion for new trial.
You want me to back up or go forward?
Forward, please don't back up.
Maybe, I'm not sure if I said this one or not.
And your investigator is trying to get your attention.
Oh, I'm sorry. I think I said this, but let me repeat just to be safe. The state's response, page 23, does not submit any facts or law to counter defendant's argument that trial counsel provided ineffective assistance of counsel by failing to utilize an expert witness. And that, of course, is very important so far as the juvenile forensic expert and also the ballistic, the DNA forensics. The state's response does not object or submit any evidence or case law to counter the arguments that the guilty verdicts at defendant's jury trial are contrary to the principles of justice and equity because of ineffective assistance of appellate counsel and the failure of the trial court to appoint substitute appellate counsel. And I can point out why that's important, but it seems like you just wanted me to say what they weren't objecting to.
The latter.
Okay. And I do want to have some further conversation about exhibits, but I don't want to mix things up.
Okay. All right. Mr. Armstrong, we're going to take our break before part 2 of this morning after you briefly respond.
Okay.
And you don't need to address the first part about Picayune and things like that. I want you to focus on the claim that there are, and I'm simplifying what Mr. Hort said, it was more sophisticated, but basically you've conceded on certain things because there was no objection to it or there's just silence. And so if there's not a response to it, then that's a ground for new trial. And here we are, we should have a new trial.
Absolutely not. There is no requirement that the state provide all of its argument and its responses, especially since the defense has an evidentiary burden of showing error and such things. Other than the fact that the defendant at trial testified that he had not reviewed his statement prior to his testimony, which he admitted was a lie and included lies, so why would you review it? That no, I don't agree with any of those assertions that I concede things because I did not specifically object to them. If I had to do a scansion of Mr. Hort's motions for trial and respond to literally every assertion, you would have had probably a 500-page brief. You heard that there's 314 separate citations for asked and answered or form of the question questions.
I don't want to see his bill, but it's very thorough.
There were no personal attacks in the ways that Mr. Hort has mentioned. Simply, I don't know Michael Waters and I don't know Investigator Alleg, This is not to say anything imputing against him. I assume that they would have Mr. Waters here to testify. I'm not going to agree that that affidavit is Mr. Waters' affidavit, and it's not a personal attack to say putative. That's a normal way of saying that's what it asserts itself to be. I don't know that it is that.
Right.
Another thing is he talks about my response to the Exhibit B, which is unsigned, has no date whatsoever, is single space types. It's just a statement of some kind out there. Mr. Waters' putative affidavit in subsection in Exhibit C literally does support the state's case. He talks about what we were doing and how Leslie got Miss Blaylock out of the car and those things, showing that he was an active participant in the hijacking. So even Michael Waters' Exhibit C, if it is in fact his new statement, it is not a valid statement. And there's other reasons why that information is incorrect in it. The Jackson Dino transcript, I do believe exists. It did happen. It was my understanding that it was going to happen on January 31st, 2001.
Is this the one where if you click it in Odyssey, it gives you a different transcript?
Correct. It gives you a transcript I think was already in there from other parts. And so what I would suggest to the court is to ask for the clerk's file to be brought to the court so the court can see what all transcripts were filed, because also the transcripts that are there are not under the correct notation. And so one with one date will be under another one, and one with that date will be under the other one. I don't know anything about whether there was a SB 440 hearing. Over the weekend, I did read one of the ancillary transcripts in which Ms. Ross said there was a hearing and one here. I don't know what that hearing could possibly have relevance for today, because as I read the law from 2000, other than the DA's office declining, there was no other way for the case to get to juvenile court. And so at most it would be, I would
Because
imagine,
of the nature of the charges? Or when you said there was no other way? Mr. Singleton was 16 at the time.
correct. The law has changed multiple times.
Yeah.
It changed in the mid 90s. It changed, I believe, in 1999, and it's changed since then.
Okay.
So I think it was in response to the Lewis case. Mr. Hort cites that opinion as referring to the court suggesting that maybe a mental health evaluation would be appropriate in making a decision whether to send it. I don't believe the juvenile court at the time of Mr. Singleton's case could even choose to keep it, as opposed to it being in the original exclusive jurisdiction, actually just the exclusive jurisdiction of the Superior Court, because of the charges for armed robbery with a firearm and, more importantly, murder. Mr. Hort does argue that, well, felony murder shouldn't be murder, but case law is against him. And so I'm not aware of any transcript for that. I don't know of any purpose. And so I'm not going to say anything about Judge Edie. I don't know if that's what was happening. I have no information one way or the other whether Mr. Bouchard sat down with Mr. Singleton. However, a court's or anyone's review of his cross-examination of Michael Waters or his direct examination of Leslie Singleton will lead you to believe that this person was unprepared and had not spoken to his client. The record itself shows a very thoroughly well-prepared attorney presenting a very, very clear argument on bad facts. The issue about, oh, the state doesn't respond to ballistics, I did, even though it's not like a civil pleading where you have an answer, I did respond to each of them and said, not deficient for these things. I did not feel like I needed to go into further detail, especially for things like ballistics, in a case where the defendant admits, yes, I was present for the shooting, and yes, the gun used was the one that I gave Mr. Waters a few hours before the shooting. That's not something that would be germane to a defense, that Mr. Waters did these things, Mr. Singleton was just dazed and confused. Also, DNA, Mr. Singleton, all of that, it was acknowledged that he was shot in the car. I don't understand what he is saying as far as what experts would show for that. As far as Detective Martin's mother, the officers did indicate, and they did get her out of Clayton County Jail so she could be present for his statements, because they wanted mothers to be with their children for their statements.
I'm confused. Detective Martin's mother? They got Mr. Singleton's
mother out of Clayton
County Jail for the interview.
Correct.
Okay.
And so he's saying that basically there was this hope of benefit that this person was going to go scot-free, whereas the record indicates that He was brought out for the purpose, she was brought out for the purpose of being with her son when he made statements to the police, which happened. The state does not concede that Mr. Waters' trial testimony was false testimony. Absolutely not. Mr. Waters' purported affidavit, subsection Exhibit C, appears to be lies. It includes assertions that, oh, Mr. Singleton didn't give me that gun that I testified he gave me in the hours before, which, by the way, Mr. Singleton testified he gave me in the hours before. Oh, no, I had that for a long period of time. And so there's a lot in the purported affidavit that is false itself. Nothing that is indicated at trial is indicated to have been false. And one of the things I was actually going to ask the court was to direct Mr. Hort to, by the end of today, give meat to his assertion of his Napaway claim. Because do I need to call in Sheila Ross and every one of the investigators who talked to Mr. Waters at different points in time, including his attorney, Mr. Mathis, who I have reason to believe, based on a transcript that's not an official transcript, but was present when he spoke with Ms. Ross and the investigator? Do I have to call in all of these people to refute an affidavit that seems patently false on its front end, but I am not aware of what he is saying is false, because his client testified and testified to virtually everything other than intent. The one issue that there was a material difference between Mr. Waters and Mr. Singleton is the issue of masks. Mr. Guichard dealt with that very deftly, and it cannot be said that the state had any reason to believe that was false testimony from Mr. Walters, and I don't believe it was false testimony because in both the police reports that we have and in the appellate court decision from the Clayton County case, which Mr. Singleton made statements to others that he obtained the gun from the officer, the deputy in Clayton County, is that he was wearing a bandana as a mask at that point in time. And so based on the different information that was before the prosecutor at the time, if that's the only difference, there's no possible claim that the state presented knowingly false testimony. Absolutely not. There's no showing here that is false, but I need to know the extent of that. So do we have to have 8 witnesses come in to testify to, so that you don't have a circumstance where you have a prosecutor who's no longer with the office who didn't have the opportunity to respond?
Okay. Got it. Let's take a 6-7 minute break. And during the break, you can let everyone else back in. We'll pivot back, Mr. Hort, to whatever witness or witnesses you want to try to fit in today, and you can release others. We'll have about an hour left. So you have the best sense of the order in which you want to call them, and you may want to change it given that we only have an hour, and if we get through 3 of them, they don't have to come back next time. But I defer to you on that sequencing, but we'll have about a little less than an hour.
I did want to respond to Mr. Armstrong's comments as far as whether he needs to call witnesses.
So we're going to talk about that, but we will go back and forth for it. But I want us to be very thoughtful about how we do that, so we don't unnecessarily get witnesses from either side.
Yep.
And we'll talk about the whole Waters piece. But since Mr. Waters isn't one of those witnesses you were going to put on today, let's work through however many we can.
Okay.
Okay. Thanks.
Okay.
South Georgia, where about?
Glenn County for
Get out.
15 years, and a little bit more, and Albany for 6.5 years.
Under Keith Higgins or?
Oh, no, as a child.
Oh, I thought that's where you were. Where'd you grow up? Where in Glen County?
On St. Simon, starting back when it was a real place, before
You
all
go
the rich people from
Frederica or
Atlanta.
Glen
Oh, God,
Academy?
no. The public school, yeah.
My kids all went to Glen Academy.
Oh, wow.
Yeah.
Your name sounded familiar.
Yeah, I was there in Brunswick for 21 years with the FBI. So I'm sure the entire time you were.
I interned with the U.S.
Child.
Attorney's Office in 2007, so I might have seen your name at some point.
Under Ed Tarver's regime?
No, this was between individuals because Lisa Gobby Wood had just been made a judge and whoever followed her had not been appointed yet. So I think Michael Moore was the acting AUSA.
And my wife was Judge Wood's judicial assistant.
Oh, awesome.
Her time.
Is her impression as positive as mine is? But I have a very, very limited set of exposure to Judge Wood.
So I knew Judge Wood as a defense counsel and did her background for U.S. attorney and then subsequently for the judge. So if there's anybody that would have known anything that was, you know, less than stellar about her, I guess I would. But what I would say about her is this. My youngest daughter is an attorney today because she idolizes Judge Wood. Not because of anything I did, because of Judge Wood.
Yeah, I like her a lot. I can't say she would never be able to pick me out of a lineup or anything like that. Not at all.
She's spectacular.
But I think the world of her.
Yeah. I don't know anybody that, well, I imagine there are people that don't, but I've never met anybody that does it.
This is not to say anything bad about the Savannah division of the U.S. Attorney's Office, but one of the reasons that I applied there was that Judge Wood had spoken at my law school class, and so I was hoping to work with her, but she was literally like 2 months, if my memory serves.
She, as the U.S. attorney, had probably the best stable of trial attorneys in that office. Jim Durham, Brian Rafferty,
Yeah, they were
Brian
lovely.
McAvoy. They were spectacular.
Everybody
Well, they
can
are
hear us if we talk.
spectacular, but none of them are there anymore.
Did some of them retire?
They're all in private practice now.
All of them?
All of them.
I know
Everybody
Amy
can hear us if
Copeland
we
is.
talk.
Amy is.
Because I see her every once in a while when I see Supreme Court arguments.
Jim Durham is a founding partner with Griffin Durham.
We can talk
Brian McAvoy.
after the hearing is done, if that's possible.
Brian Rafferty.
Who is that?
Brian McAvoy. He may
Okay,
have been
he's up
before
here,
me.
right?
Yes.
Yeah.
So Brian Rafferty he was with Baker Hostetler, but now private, by himself. Brian Tanner, did you know Brian Tanner?
If I did, I've forgotten the name.
Supreme appellate writer.
There was only one appeal there, one appellate attorney there, and that was Amy Copeland.
Amy was there, she's no longer there, right? But Brian was probably at the time you were there, he was still trying cases then.
Okay. No, yeah, he was there.
Judge Woods come in and testify, you wouldn't make up an affidavit.
Judge Wood.
That is still very irritating. Come on.
Judge Wood just swore my youngest in the Southern District.
What
I
now?
never accuse you of that.
It doesn't matter about his truthfulness. It's Michael Waters' truthfulness. He
No,
needs to come in and testify to it.
The affidavit, yeah, but it's purportedly signed or purportedly by Mr. Waters. You're saying this guy made it up or got somebody else?
I'm never going to say that an exhibit that I don't personally know anything about is what it says it is.
No, I'm not asking you that. I'm just asking that it be admitted.
We see
for what
this
it is.
phrase as wildly different.
Well, yeah, but you know me, and you certainly would have known him if you would have done a Google at all.
That's not the basis by which I make those assertions.
You know what I'm saying? You're not doing your job. You're taking the easy way out.
You do realize that you keep saying that all these things are personal attacks on you, but you actually have made a number of personal attacks on me in email, now in person.
Such
You
as-
just said, I don't do my job.
Well, come on, Kevin.
When I responded, because I did
would
not
never say
believe
you
that,
made up an affidavit. I would never do that.
when I responded that I did not believe Michael Waters' Exhibit C or whatever it was, you responded like, I think you should see this rule. And I
Yeah.
said, like, what rule is that? Because you didn't say, and you cited back, and it was the rules about presenting false testimony, assuming that I knew it was false testimony, which I don't believe it was false testimony.
I'm still contemplating whether I need to report you.
Okay, cool. Do that.
Well, come on. For you to say that I made up the affidavit.
At no point have I said you made up the affidavit.
What does
None.
reported mean?
Purported means there's an affidavit. I don't know anything about it. And until Michael Waters testifies, my objection is going to be hearsay.
And if you would have said that, I wouldn't have this discussion.
If you want to report me to the state bar because I used the word purported to refer to an exhibit that I had never seen before.
Signed by someone purporting to be Waters. That's what you're saying.
Correct.
So you're saying that he didn't check it out. It got just signed by whoever. You're saying that I then submitted that into evidence.
The
Signed
person
by
could have lied that they were
someone
Michael
purporting-
Waters and given you false identification.
Yeah, right.
People in the Fulton County Jail, we actually had a murder case reversed because people were using each other's information, and the person who claimed to have been a witness was actually in the Fulton County Jail at the time, that he could not have seen what had happened because they kept switching information, because people misidentified who he was because he was using somebody else's information at the time.
I'm sorry, Fulton County Jail is probably not the best example.
But you're saying that I'm making a personal attack.
All right, all right, all
Absolutely
right.
not.
Stop. Ms. Rivers, are you good to go?
Yes, Judge, I'm ready.
Great, thank you. Mr. Singleton, things still good at Ware State? Yes, great, thank you. All right, Mr. Hort, your witness stand.
Yes, and I would like to know if Mr. Armstrong is objecting to all of the exhibits, including the ones that came from his office, including transcripts, or?
So it's a fair question, much like I understood why he was objecting to the wholesale admission of A through O. I thought you might say, well, are you objecting to everything, or are there some things they're from the court's docket and so they ought to come in? I'm going to ask you to work through that, maybe not on our collective time. Thought maybe you'd be talking about that during the break, but you were talking about something different. We can go through one at a time to see what's your objection to A. It's a transcript. I'm making this up, but A is a transcript of the suppression hearing. What's your basis for objecting? It's already in the record. I don't know why we need to get in the record again, but you may have a good reason for doing that. But I'll ask you guys to work through that, not on the collective time, because there may be some that we can get in the record and you don't need to bring in the clerk of court to authenticate that it came from the docket.
Fine.
Okay.
I just need to know if I need to bring in more witnesses.
Understood. But when we wrap up today, I'll take the Zoom session offline so everyone else can't hear what you guys are talking about. I'm going to be meeting with some interns and we'll talk, and you two, that'll be my request to you all, is to work through the A through O. So you'll know, when we meet next, I do need to have so-and-so to authenticate it. Like you, I found Mr. Armstrong to be reasonable about these things. He's not going to have you bring in someone from the clerk's office to authenticate a court record, but I don't know about Exhibit C, if that's the Waters affidavit. And that's a hill you're going to need to figure out how to climb.
And if it's possible, I would like to talk to Mr. Singleton too. Is that a possible option? I'm not sure what the prison has so far as how long.
There'll be two options that we can sort out. One would be you dial into the Zoom on your phone, and we'll just leave the two of you as the last two in there so you can speak. Or they may have a number you can call. There seems to be someone who's helping out. So when we wrap at around noon, remind me that you want to connect with him, and we'll figure out the best way to do that.
Okay.
Okay.
Did you want opening statements at all? Or do you want to
I don't. Nope. You have well documented your thoughts and concerns in your various motions.
So the defense would call Dr. Tacker to the stand.
Okay.
I believe he's still sitting outside, so he didn't hear anything he shouldn't hear.
Before you bring that person in, do the witnesses overlap at all? Meaning you also have a Dr. Jones who might be asked the same things, or can we just let everyone back in because each witness is talking about a discrete thing and wouldn't be influenced in an inappropriate way by the preceding witness's testimony? Does that make sense?
It does, except I have suggested to the other witnesses that they, instead of having to sit on the hallway, they can go home or go back.
Oh, then there's not an issue. Okay. So how many witnesses you have left? Just one?
Doctor and possible Mr. League. If we
Oh, well, he's staying in the courtroom anyway. So let's bring the good doctor in, please.
Okay.
You swear and affirm that testimony which about to quote the true culture you may see.
And we need to adjust this monitor because that's how folks are going to be able to see you. I'll let you slide it around, rotate it.
You may say and spell your full name for court record, okay?
And then does it say on the screens, if you click the stay mute button, please. Great. All right, thank you.
My full name is Anoop Tacker, Anoop, last name Tacker, Takher.
Your Honor, if I may ask, does the state have any objection to Defendant's Exhibit A? That's the forensic evaluation by Dr. Tacker.
No objection at this time.
All right, Exhibit A is admitted.
Your Honor,
Assuming that it is the doctor's report. Oh, I have a copy.
up to you or?
I'm the keeper of the exhibit, so that's where it goes. Thank you, sir.
Doctor, if you would give us a little bit of a history, education, work, what are you doing now?
Yeah, so I completed my undergraduate degree at Benedictine University in Illinois, went on to do medical school at Campbell University.
Can you move a little closer to the microphone? It doesn't move, unfortunately. I mean, it bends up and down, but that chair has no wheels for good reason. We've had witnesses roll off the witness stand. You're not going to roll anywhere with that one, but
Not going
closer to the microphone is good. Thank you.
Sounds good. So I completed my undergraduate degree at Benedictine University in Illinois, went on to do medical school at Campbell University School of Osteopathic Medicine in North Carolina, and then went on to psychiatric residency in Western Michigan University, and went on to child psychiatry fellowship at Rush University Medical Center. And I'm currently in a forensic psychiatry fellowship at Emory University School of Medicine. And along the way, I completed my master's of jurisprudence at Loyola University Chicago School of Law. And currently I hold 3 active state medical licenses in Georgia, in Illinois, in Michigan, and I'm currently board certified in adult and child psychiatry.
Your Honor, we'd offer Dr. Taco as an expert in adult, child, and forensic psychiatry.
I'm curious, your title at the end of your report is Anoop Tacker, DO.
Yes.
What is that?
So DO is Doctor of Osteopathic Medicine. So there's generally 2 types of physicians, DO or MD, the more common one being medical doctor. A DO is very similar in the regard to the training we get. However, we get more training with osteopathic principles and looking at patients from a holistic view in mind, body, and spirit.
Okay. Can a DO rather than an MD also be a psychiatrist?
Yes. So all of the residency and fellowship training I completed were MD fellowships.
Okay.
And residencies.
Great. Mr. Armstrong, do you have any questions of Dr. Tacker concerning his qualifications as an expert?
I do not.
Okay, then I will certify you for purposes of the motion for new trial hearing for Mr. Singleton as an expert in the field of
Adult, child, and forensic psychiatry.
those things.
Doctor, let's start out. Any initial thoughts on this case?
Objection, Your Honor. Vague and not directed.
Let's keep things focused.
Doctor, you did a forensic evaluation of Mr. Singleton.
Yes.
And what did you determine from that forensic evaluation?
So from the forensic evaluation that I did of Mr. Singleton, I determined his overall psychiatric status, we looked at his developmental factors at the time of the crime, and then assessed his overall risk of future violence.
And what can you tell us about him then and now?
That Mr. Singleton now is a rehabilitated individual. He has expressed significant remorse for his involvement in the crime that occurred. He displayed a degree of insight that he acknowledges that his involvement led to the crime that is being addressed here today. However, he used that and his incarceration to better himself, to make an impact in the lives of others based on what he has been through. And he was able to show significant character development, remorse, regret, and actions that show that he has become a rehabilitated inmate.
You, I believe, spoke with him on 2 occasions.
Yes, so I spoke with him on March 13th and March 27th.
And then plus you also had, in doing this evaluation, documentation from other sources.
Yes.
What can you tell us about, from your evaluation, what he was like at the age of 16?
Objection, Your Honor, hearsay. That is Mr. Singleton's statements to Dr. Tacker.
And I think as an expert witness, he's entitled to do that,
He's entitled to do what?
to testify as an expert witness upon his evaluation.
So, Mr. Armstrong, I know experts can rely on hearsay in forming their opinions, read books, talk to people, et cetera. Your objection isn't to the fact that he relied on it. It is to his recitation of the hearsay that he received.
Correct, as far as how Mr. Singleton was at the age of 16.
Okay.
I think the court answered the question when he can rely on information that he was given. And I've already brought out that he's talked to Mr. Singleton twice, plus he had other documentation.
How would Mr. Armstrong, Dr. Tacker relay to you and me and Mr. Hort, I guess I'm the fact finder, but the fact finder, ways in which Mr. Singleton has changed? If he can't say when Mr. Singleton was 16, he got arrested or he got expelled from school, things like that.
It is my understanding that an expert who is being proffered by a side can testify to their opinions. They can testify to things that are in their own knowledge in the sense of how psychology works and things of that nature, but they cannot be a conduit for hearsay. I will be frank with the court that I intend to ask this witness about admissions that the defendant made to him under the party opponent exception to the hearsay rule, but specific things about his life at the age of 16 by the proponent I don't think is admissible over hearsay objection.
I think that's right. I think what we're limited to, Mr. Hort, is that the doctor can say, based on what I learned from Mr. Singleton about how he was acting, living, behaving when he was 16, I recognize these changes, that kind of thing. But I don't believe, so I'm sustaining the objection. This isn't the appropriate way to get in what Mr. Singleton has said life was like for him when he was 16 or 17 or 18.
I then would ask to be able to make an offer of proof, because this goes right to the heart of our case, that they should have got a juvenile forensic expert. And this is what the expert would have found out, being right then and there 20-some years ago, and then would be able to testify as to what this meant.
Okay. How, Mr. Armstrong, would Mr. Hort get in front of me? I know a common stumbling block for an attorney in Mr. Hort's position when he says, hey, the outcome could have been different if we called an expert, is you need to show what the expert would have said.
Yes, but you also have to do it in a way that shows that he could have gotten it under admissible evidence, not that he could have done it in an inadmissible way. Now, he can have his client testify to this information, and we can conditionally accept this information on the assumption that Mr. Singleton is going to testify to the same facts.
That's the only way I could think of it, is that Mr. Singleton would need to say under oath on the record, here's what was going on in my life when I was 16. We could conditionally ask Dr. Tacker, if you had a client who age 16 was working through these issues, mom in jail, this and that, and you see them doing this now, does that indicate rehabilitation? But to get the data from life as it was for Mr. Singleton in the year 2000, we'd need to know that Mr. Singleton will be available to testify to that.
Yes, Your Honor.
Okay. I think that's where we are. And maybe you were always planning on doing that.
You're saying an expert cannot testify as to what the expert learned or was told?
I think an expert can testify to what he or she learned generically, but I'm not aware of an exception to the prohibition against hearsay that would, this is not medical treatment right now, where the expert could say, oh yeah, I talked to Detective Martin and he told me X and Y and Z. Detective Martin needs to talk about what Detective Martin says or experienced or did. If you're aware of a hearsay exception that would allow Dr. Tacker to say, Leslie Singleton told me that when he was 16 years old, life was difficult for him because of A and B and C. Because there's no way to cross-examine Mr. Singleton. Mr. Armstrong can't call Mr. Singleton.
Mr. Armstrong can cross-examine Dr. Tacker.
About someone else's statements, but that's the whole reason why hearsay doesn't come in.
What he plans on doing anyway, except for he just wants to bring in certain statements.
Well, the defendant is in a unique position because you can call him and Mr. Armstrong can't. If we stick with my Detective Martin example, if Dr. Tacker had spoken with Detective Martin recently about what was going on back in the year 2000, you could not elicit statements over objection of hearsay about what Detective Martin told him. And the same would be true for Mr. Armstrong. The exception would be if it is an admission made by your client. That's because the state can never call a defendant to the stand. We're in that unique space where a little bit of what would otherwise be hearsay could come in because of the witness you're asking him about, i.e. your client. Ask him about any other person he may have spoken to. You may get a hearsay objection, but it would be equally improper for or inconsistent with the rules of evidence for Mr. Armstrong then to get up on cross-exam and say, tell me about what Detective Martin told you. You'd say, that's hearsay.
So you are saying that I need to bring in as witnesses all the people that authored the documents that he also received?
Not necessarily.
Because that's information that he received from an outside source.
But if he's not getting into the contents of the documents, I reviewed a psychological evaluation that Mr. Singleton had 2 years into his stay in the Georgia Department of Corrections. And based on my review of that, I conclude that he was suffering from major depression at that time. He's not anymore. Hey, look, something's changed. But your question was going to require Dr. Tacker to say, here's what Leslie Singleton told me, as opposed to I synthesized a report that someone authored. And in my expert opinion, that report tells me that at this time, Mr. Singleton was working through PTSD.
And I think I understand the court's ruling. It's certainly different than Michigan. And it just, I guess, surprises me that an expert can offer their opinion, but they can't then disclose what the basis for that opinion was.
So he can. I interviewed Mr. Singleton twice. He can't get into the contents of that interview, but based on my interview with him and my review of medical records from GDC and a conversation with his sister and a review of the docket and a trial transcript, I reached this conclusion.
And again, we're not talking about a jury, we're talking about a court, a judge.
But I'm talking about a hearsay objection, and there's not an exception to hearsay that judges are different from juries.
But my point was that it's easier for this court to know that it's not substantive evidence, whatever Mr. Singleton told him. It's only as to what is the basis for his opinion.
And if it was anyone other than Mr. Singleton, I might be a little more flexible about it because the state could always then call that witness. If the state felt that it was important for me to know really what Detective Martin said because they think that it was being misconstrued or misunderstood or misrepresented by Dr. Tacker, they could call Detective Martin. They cannot call Mr. Singleton.
I guess my thought then is that I need to say, assuming this is what Mr. Singleton will testify to.
Right. And the remedy would be, and this is where it's good that it's a judge and not a jury, is if Mr. Singleton says, I'm not going to testify, or his testimony is different, I can always disregard what I heard from Dr. Tacker.
Even his opinions?
No? Well, I mean, if what's called into question is, if Mr. Singleton is refusing to talk about what he told him, I think I'm entitled to wonder about that substance, but you should proceed knowing that hearsay applies here.
And again,
Georgia hearsay applies here.
I do reserve my objection. So doctor, I don't know how much you followed along with that, but we're not going to go into what Mr. Singleton told you.
Okay.
I just want to be clear, we're not going in specifically like he said X or Y or Z, but it may well be you're asked, well, based on your conversation with Mr. Singleton, what did you conclude? Don't think, am I allowed to answer that? There are ways in which you'll still be able to testify.
And that's what I'm going to do. I'm going to be asking for your opinion, but not per se what Mr. Singleton told you. Now, you also had other sources of information?
Yes. So I based my opinion off my 2 interviews, police reports, provided court documents, the offender disciplinary history, the offender programs history that I was provided, and then a few other documents that I was provided.
When you say disciplinary history and program, those would be things from the Georgia Department of Corrections. In other words, documenting how Mr. Singleton has done or not since he's been in custody.
Yes. So the title of the document was Offender Disciplinary History, GDC ID 108.
Okay, and you don't need to, but so that would be a GDC document.
Yes.
Thank you.
So let's start with your opinion. With the evaluation that you did, the sources of that or for that evaluation, your thoughts,
So
opinion. Not what people told you, but what analysis, what opinion did you derive from this different information?
So based off my evaluation to a reasonable degree of medical certainty, it was described to me that Mr. Singleton had a tumultuous upbringing that impacted his actions at that time. And from what we know about adolescent brain development and character development and impulsivity, that all had a factor into the actions that led to the crime. Throughout the years, over the last 20-something years that he's been incarcerated, he has shown significant progression based off of the disciplinary history, his programs that he participated in, his book that he wrote that shows a significant deal of positive thinking, remorse, and how to think positively for other people in this situation. So he has shifted his mentality to a outlook that he is trying to make an impact in his own life, others' lives, while still maintaining accountability for the crime.
Would it have then been helpful for the defense, for purposes of trial, to use a juvenile forensic expert?
So I've been practicing for the last 5 years, 6 years. I don't know in particular what could have been done 20 years ago. I was probably like 10, 15 years old. But I can speak to, what I would do with a person that I would evaluate today. I would look at the person's maturity, psychiatric status, and how those intertwine into the behavior that could come out.
Would you agree that this could help explain the why and what happened in this case?
It could help explain his level of maturity and his actions at the time. But I don't know that I would be able to comment on 20 years ago from this interaction that I had with him.
Would you agree that a forensic evaluation, whether it's 20 years ago or today, would be helpful to understand what happened?
I think a psychiatric evaluation would be helpful to just assess the overall status of an individual and their mental capacity, their mental functioning.
Recognizing that you are not a Georgia trial lawyer, would using a child forensic expert have helped in formulating questions to ask during trial?
Objection, speculation.
So would you, in answering that question, would you be speculating, or do you have a informed professional opinion on that question?
I believe it would be speculation.
Okay, then don't answer the question. Thank you. Next question.
Would you have suggestions so far as questions for a lawyer to ask at the trial based upon a psychiatric juvenile evaluation?
Yes, so based on my evaluation, I do think it's important to consider developmental status of an individual, the mental capacity at the time, and overall environmental circumstances at play.
Would you agree that this maybe could even help so far as a resolution of the case short of going to trial?
Objection, Your Honor, speculation.
So were you asking generally that getting an evaluation could help with that process as opposed to specifically in this case?
A juvenile forensic evaluation.
Yeah, in general, if one gets it, that could be something that could assist in a non-trial resolution.
Yes.
Yeah, you can answer that.
So I believe getting a juvenile forensic evaluation would help understand the individual situation. I can't speak to how that would change a proceeding.
Generally, then, would a juvenile forensic expert help so far as trial strategy? Can you answer that, or is that speculation?
I believe a forensic expert would be able to help understand an individual's mental functioning, their other factors, including impulsivity and overall character. And I think that would be something that could be presented in a holistic view of an individual and how to approach a certain crime.
What about helping the jury to understand impulsive behavior?
Yes, so if we were speaking in front of a jury, we would be able, I am discussing right now as well, the character development, impulsivity of adolescence, and how that brain development continues until early 20s, and how our judgment, our actions are all connected, and how that would still have growth through the early years of our 20s.
The personal data that you put in the evaluation so far as Leslie when he was 16, did that all come from Leslie, or did that come from other sources?
The fact that he was 16?
What he was like when he was 16?
So my understanding of what Mr. Singleton was like when he was 16 was based off of his report.
Meaning words he gave to you, an interview, the 2 interviews you had with him.
Yes.
Okay.
So none of that was based on conversations with other possible persons?
So I did not speak to other individuals, like including his family. I did speak to yourself, Mr. Hort, but that was it.
How would it factor in? What is your opinion so far as if Leslie at this time felt that he was responsible for his family, and by that had to do things for their well-being?
How would that factor in right now?
How do you have an opinion there as to whether that would be a factor that a juvenile forensic expert would be helpful to so far as the trial or preparation?
Yes, I think that is under consideration when we are assessing overall behavior of an adolescent, in the component of adverse environmental circumstances. So if an individual is under duress in a situation, especially a child, then it can affect overall behavior and judgment and actions.
I expect his sister to testify that at the time he was the oldest in the house because she had left home due to an abusive environment, that he suddenly went from being the younger brother to being responsible and leaned on for financial help and taking care of the family. Is that something that would factor into this juvenile forensic evaluation or your observations as an expert? and this case?
That would be a factor, and Mr. Singleton did inform me
So
that,
don't go into what Mr. Singleton said. You're getting a hypothetical now. Mr. Hort's being creative and he can ask you hypotheticals. And so just let us know how if what he said, you assume it to be true, then that would mean X to a professional like you.
That's again, I'm assuming this is what his sister is going to say. So I'm not using Mr. Singleton, but assuming this is what his sister says. If you then could follow the judges.
so if his sister testifies to that.
Or told you, I mean, just you ended up getting a chance to speak with her and she said, you know what? I moved out of the house earlier than I intended to. It was a tough situation there. And all of a sudden, my little brother wasn't the little brother anymore. He was whatever words Mr. Hort used. So he had responsibility more so than maybe a 15 or 16-year-old in other households might have.
Yeah, I would look at that under the adverse environmental circumstances and how that puts duress on an adolescent and how that can affect his behavior.
Assuming again that the sister testifies that Leslie went through some really tough stuff. Sexually assaulted by a female friend, mental and physical abuse from his mom. Your thoughts, your opinion as to that effect?
I think that can all affect the overall psychiatric status of an adolescent, let alone any individual. And that can affect the environmental circumstances that he is in. And like I've said before, with the other situation, that could affect his behaviors and his actions.
I strike that. I expect the sister to testify that there was a lack of parental guidance, familiar instability, and socioeconomic adversity, trying to figure out how he would eat, etc. Why his mom was in jail. Would that be a factor? What can you offer so far as your analysis or opinion of those circumstances and the need then for a forensic juvenile expert?
I believe it's very similar to what we have discussed, where it affects the adolescent and any other individual in a similar way, that it can affect the overall psychiatric status. It can affect the impulsivity component, the judgment on maybe trying to make amends or trying to make a situation happen, per se. I believe, given that he was a 16-year-old at that time, it can have a significant impact.
What about peer pressure at that age?
Mm-hmm. Yeah, we do know that adolescents are significantly more prone to peer pressure. Their judgment is not as that of an adult, so it can definitely affect the behavior, the actions that are done.
And what about so far as interaction with police officers? I guess, is there a distinction there between white 16-year-old boys and black 16-year-old boys?
So I don't think I understand the question.
I'm not trying to either lump everybody together. My question is your opinion so far as Leslie's interaction with police officers, and by that black 16-year-old kids.
I'm not understanding your question.
I'm trying not to lead him.
Okay, we'll go ahead and lead to just get the question out there, and then maybe this will be one where a non-objection to leading isn't ineffective by the state. We'll see.
So far as a juvenile forensic expert, what analysis or opinion can you offer so far as Black 16-year-olds and their trust, their contact with police officers?
So I can.
Other than like what you read in newspapers, in which case you're not any more of an expert than anyone else who reads newspapers.
I believe any adolescents, whether their race is white, Black, have a different response to judgment and authority figures. I believe that, that there could be a degree of fear or anxiety in speaking to authority figures. I don't necessarily, I can't say to like a reasonable medical certainty of how his interaction would have been different from, say, a white 16-year-olds.
No other questions.
All right.
Your Honor, do you prefer the podium or the table? I'll be using my computer for a bit of this.
I prefer Ms. Rivers being able to hear you, and so that's a microphone. If you want to have a handheld microphone and be in the back of the courtroom, you can do that. I just need Ms. Rivers to be able to make a good record.
Understood.
So whatever works best for you.
Doctor, good morning.
Good morning.
You met with Leslie Singleton, correct?
Yes, I've met with him twice.
And on page 3 of Exhibit A of your report, you have a copy of it in front of you, correct?
Yes.
On page 3, there's a section about notification of rights. Could you explain what that process is, please?
So the notification of rights is informing Mr. Singleton of the evaluation, informing him that it is not a confidential evaluation, that Mr. Hort, the judge, yourself may be receiving this evaluation. So anything that he tells me may go into this report.
Okay. Now, on page 8 of your report, there's a section called Mr. Singleton's account of the offense. Did you talk with Mr. Singleton about the crimes?
Yes, so he walked me through his account.
Okay. And you said that he was remorseful for his involvement.
Yes.
Okay. I'm going to go through a certain amount and I'm basically asking, did Leslie Singleton really tell you this?
Okay.
And so I'm going to start at the end of the second paragraph. Did he really say, and it's in quotation marks, my plan was to get some dope and get some crack from a known drug guy in the area and sell it, in quotes?
John, I would object. The report speaks for itself. There's no indication the doctor is adding or not correctly reciting information. Everything's right in the report for you. You don't need to know what Leslie said.
Well, I think it's important to establish the significance of quotation marks. Was this recorded? And he got it from a recording. So I'm going to allow it up to a point. We don't need to ask 30 questions about if it's in quotation marks, did he really say it? But right now we're understanding what it means for the words to be in the report. So if you remember the question, you should answer it. If not, he'll ask it again.
Yes, so if I quoted it in my report, that is what he told me.
Okay. The next paragraph describes an incident where he and some others held a pellet gun against somebody and took their bag from them. Is that correct?
So.
Got the same objection.
Okay, overruled.
That means you can answer.
Sorry.
I guess I would object. Is that correct? Means what?
Is this?
Yeah, let's clarify the question. I viewed it as we're now, instead of going line by line, we're saying, and did he relay this to you? And so that's the level of defocusing that I had hoped for and looked like was happening. but why don't you ask the question again so it's clearer about what correct means?
Did Leslie Singleton relay to you that he was present for an incident a few days before the murder in which a bag including a gun was taken from somebody else?
So he informed me that he was involved in an incident. And then he didn't directly state that he stole the bag. As I stated in my report, the individual dropped the bag and then they had it.
The individual they had a pellet gun pointed at under his statement.
Yes.
And one of the things that he obtained from this was that person who claimed to be a police officer's gun.
Same objection, Your Honor. He's not asking, did he say that? He's asking him simply to repeat what's already in the report.
Literally, if you want me to say every single line, did Leslie Singleton really tell you this sentence? I will do it.
No, I'm okay with your approach. Overruled, you can answer the question.
What was the question?
Did Leslie Singleton really tell you that they took that bag you just testified about from that individual while they held a pellet gun on him?
Yes.
And did Leslie Singleton tell you that he acquired a gun from that bag?
Yes.
And did he tell you that he gave that gun to a co-defendant?
Yes.
Okay. Moving on to page 9. Did Leslie Singleton tell you that he and his co-defendant planned to visit a guy in town to buy drugs so they can sell them?
Yes.
Did he tell you that he and that friend came across a couple fighting in a car?
Yes.
Now, this is in quotation marks. Did Mr. Singleton really report, Mike said as soon as he saw this, he was going to get the car? Is that a direct quote?
Yes.
Also a direct quote, did Mr. Singleton really say, quote, I wasn't saying don't steal the car, but I also wasn't saying go kill the Maine and take off with all his stuff, end quote.
Yes.
And Maine is spelled M-A-N-E.
Yes.
Did you record what he was saying so later on you could create your report, or you were taking notes? And so you just go back to your handwritten product to generate this report?
I was typing.
Okay, so he's talking to you and you're typing kind of real time.
Yes, and I had informed him while doing the interview that I will stop you, I will type, make sure that I have everything. So I interrupted him numerous times throughout the interview. That's why I believe the first one was over 165 minutes and the second one was 80, so that I can make sure that I get everything accurately.
He would say something that was significant to you. You type it. Let me make sure I got this right. It was Maine, M-A-N-E. I'm using an example, but something like that.
Yes.
Okay.
He said at some point, the girl was screaming when Mike got the man out of the car.
That was what he told me.
Okay. Did he say, quote, that's when I was like, shit, we need to go?
Yes.
Okay. Did he tell you that he came from the street and went up to the car?
Yes.
Did he tell you he got into the driver's seat?
Yes.
Did he tell you that Mike gave him the victim's phone?
Yes.
So I thought you weren't going to go sentence by sentence.
It was the quotations, Your Honor. I'm not trying to do the whole paragraph because
Okay.
it'll be a very, very complicated.
It would.
Did Mr. Singleton tell you that he told his friend Mike to drive?
Yes.
Did he tell you that he got hit by a gunshot during this incident?
Yes.
Those are all things that he told you directly.
Yes.
No further questions.
Mr. Hort, any redirect of Dr. Tacker?
Yes, Your Honor, thank you. Would a juvenile forensic expert have been helpful to explain why a juvenile did this, what happened, impulsive behavior?
So I can't speak to, 20 years ago on specifically, what a forensic expert could have said. I can speak to if something like this were to happen now, I would evaluate the individual for their psychiatric status, for their environmental circumstances, their maturation, their impulsivity, to be able to get a holistic view of who a person is and what their behavior is like, to see if there is a degree of maturity there, or in adolescence, if it's lacking. So I think a forensic expert would be helpful.
Are the questions Mr. Armstrong asked you and the answers you've given, are those consistent with juvenile impulsive behavior?
So I don't understand.
Running, jumping into a car, let's get out of here.
I think it's consistent with the degree of impulsivity that an adolescent may have in a situation where they may not necessarily be thinking about adverse outcomes or the negative impact of their actions in that moment.
Did Mr. Singleton tell you why they were going to that drug dealer's house, why this day started?
Yes.
Go ahead.
He informed me that they were going there to buy the drugs so then he could sell them to help come up with the money to make his mother's bail.
No other questions?
Anything else, Mr. Armstrong?
No, Your Honor.
Doctor, I appreciate your patience. You were here for a while, but we're getting you out of here right about noon. Appreciate your time.
Yeah, thank you, Your Honor.
Maybe then be excused.
No objection.
You may be excused. Thanks. So we are out of time for today. There were a couple of things that we needed to talk about logistically. I don't know so much that I need to get in the middle of it as to ask the two of you to talk about it. One would be, we got Exhibit A in, so we're at B through O. We also have how the state needs to respond to, you call it a NAPAWay claim?
NAPUE is about the state providing.
Oh, I didn't know that's how you pronounced, okay. NAPUE is that?
People have said it, I can't.
Okay, got it. Yes, the NAPUE claim. And with the affidavit, and do you need to haul in every single person who might have a perspective on that it was largely truthful or the inconsistencies are immaterial, et cetera?
Well, it alleges things that he was abused and that he only made statements for different things. And while one defendant doesn't have standing to assert somebody else's constitutional rights about the voluntariness of their statement, at least that's what the Georgia Court of Appeals has said, his claim is essentially that the state knowingly presented false information, and that what was false is not clear to me because his client testified. Basically, other than the masks, which there is a wealth of information within the police reports and other things that would not have led anybody to believe that Michael Waters' testimony and that fact was false. I don't know what I have to respond to, but I want to give those individuals that they have made salacious claims against an opportunity to respond to them if there is in fact a claim.
Okay. And so are there any exhibits for which we don't need a witness foundation, and then a little more clarity on the NAPAWay as to what the state might need to bring to bear? And then you want to talk with your client. Anything else we need to sort out right now? I guess, Mr. Hort, you're going to need to get a sense of how much time you need to present the remaining witnesses so we can figure out, can we do that in one setting? Or if we know we only have a 3-hour block of time, then you don't need to get all your witnesses here if that's more than 3 hours.
And that does raise the question that I do believe we need to discuss sooner or later, and sooner preferably. I have listed on our witness list a number of defendants, not in this case, but that also were aggrieved by Mr. Gishard. Mr. Armstrong has already indicated his objection. I agree that we need to discuss that, their admissibility. Otherwise, that's going to be quite the endeavor to have all of those witnesses appear by Zoom. Like Mr. Singleton, they do not want to appear in person.
Okay. So the threshold issue is, do they appear at all? If they do appear, you may need to work through them not being here in person if the state doesn't consent to that, but it may be moot.
I've already filed a motion to that effect, but they appear virtually.
Okay.
For the court staff assistants, it might be helpful for him to identify specifically, because the motion that he filed was very general.
Well, the larger issue we have to resolve first, which is, are they going to testify at all? I'm going to ask the two of you to confer over the next couple of days about exhibits B through O to see if there are any, I guess it would start with you. Well, you can work it out how you want, but you should be able to identify the witness that you'd be calling to get it in. If that's the only reason you're bringing that witness in, it may be upon further reflection, the state says, we don't need that person, because that's just like bringing in the record custodian. And in the end, no one ever asked questions of the record custodian. But it might be more fundamental than that. And I'm not asking anyone to not push hard in the direction that they think they ought to. The Napaway issue, I'm going to send you guys an email with some guidance. And then timing. Mr. Armstrong, has the conviction integrity unit looked at this case, and is it something they're moving forward on, or it's not even hit their radar?
I included Ms. Maxwell on an email because Mr. Hort had mentioned it. However, as far as I'm concerned, there's no issue with the conviction. That would be a separate process outside of the motion for new trial.
Okay.
Which is why we are going outside of Mr. Armstrong, because he, right up front, when the court said, even agreed, you could get talk. No, we're not talking.
Okay, well, I don't want you to speak for Mr. Armstrong, and my experience with the conviction integrity unit is that they often take up cases where there's no issue with the conviction. It was a plea, but someone got 30 years for drugs, and there's been rehabilitation, and maybe it's time to restructure that sentence. That's not this case, to be clear. It's not a victimless crime. There's very much a victim, deceased, a family of that victim, et cetera. But like you, Mr. Hort, I'm not aware that the conviction integrity unit is limited only to cases where they find there was some structural defect, or we're not so sure 20 plus years later that the evidence was there and maybe there was some mistake, because there may not have been a mistake. It may well be, given the facts we're hearing, that Gary Gishard plus 6 other defense attorneys couldn't have moved the needle in a different direction for Mr. Singleton. But that doesn't mean that it's not something that the CIU shouldn't take a look at. For all the many reasons you brought to bear that don't have anything to do with guilt or the outcome of the trial, and have everything to do with, here we are 20-something years later, what is the wisest course moving forward for this, not a young man anymore, for this guy. So, but I understand they're two separate things. You're going to pursue that. You may have success, you may not. All I ask is that you keep me posted, because this is a big investment. It's a necessary and important investment. But if you're getting the sense that there's going to be movement on a different front, then we should tap the brakes on this, because Mr. Armstrong has put in a lot of work. You put in even more, and I'll be putting in work. And it will mean that I won't be working on other motions for new trial, because this is by far the oldest one I have. So keep us posted on that front.
Yes, I have contacted them. I do believe we are moving forward.
Okay. Well, if there is meaningful progress, let Mr. Armstrong and me know, please.
My hesitancy there, I certainly don't mind, but Mr. Armstrong is very determined no. And
But you can't let just me know. You have to let him know as well. Well, I guess if you're talking with Ms. Maxwell, you've got a representative of the state in that line of communications. I just don't want you reaching out to Ms. Hansberry or me saying, hey, I want to give you an update on something without someone from the DA's office on that email. You understand the importance of that. You decide who you put on that email.
Great.
Okay.
And I would like to disagree with the court that as a Michigan lawyer, I could have done this case better than Mr. Guichard. My client would not be in prison today.
Okay. I wasn't reaching a conclusion on that. I just was pointing out that may well be where this settles out at the end of everything. Were there other things that we need to address through an email exchange? The exhibits, how to flesh out the Napaway claim, and then what's next, as in when can we meet next and how much time?
Well, there's still that 404B,
Meaning the other clients.
the other defendants.
Right, but I don't need to talk to you all anymore about that. I need to give you an answer, but
Well, but you need to hear our arguments.
you don't think it's set out in your pleadings?
No.
Okay. All right. Then add that to how much time we need for our next session. Anything else?
That's why I was wondering, and I know the court is, of course, very busy. It almost seems like it would be better to have that discussion before the hearing. So GDC, your office, whoever knows about these people.
So my thought is this, yes, we'd have to have it before any former client is produced, but you had other witnesses. And so I'm not going to get a full day for this. I will get a chunk of time, and we will use that chunk of time to have what we'll call, for shorthand, the 404B piece. And then we'll roll on into other witnesses that you have who don't have anything to do with how Mr. Guichard may have performed in other unrelated cases.
That will work. Good.
Great. Mr. Armstrong, anything else?
Nothing.
All right. Thank you, everyone. Thank you, Ms. Rivers. Oh, and two things. Thank you, Ware State. What's the best way, if you could unmute there, for Mr. Hort to speak with his client now? He can call. He's got his phone right here. What's the best way to make that happen?
I have a phone number.
Would you like? Okay, I'm sorry.
287-4924.
912-287-4924.
Yes, 912 area code.
Yep. All right. I'll have Mr. Hort call that in the next 5 minutes so people don't have to wait around.
Thank you, Your Honor.
No, thank you. Yes, ma'am. Thank you so much. Appreciate your help.